Oh, hi there. Good morning, good afternoon, or good evening, depending on where you're at. We are back. I am Bob Mata, host of the Defense Diaries podcast. We are here with our continuing coverage of the case that really never sleeps, Karen Reed. So, potentially a huge day here in court today. There's so many things that can go down today, and it's a little nerve-wracking, We don't really know what's happening. Now, there was an order that came out from Judge Cannoni. Mandy texted to me first thing in the morning. She's like, "Oh, there's like it's not even an order. It's actually the schedule that's showing up on the docket. It's got today at 9 a.m., 3-4 motion hearing, and then 3-5 motion hearing, and then 3-7. It's got final pretrial hearing." And Mandy's like, "Wait a second. Is that final? What is it?" Just it doesn't mean anything. There's nothing to be read into that. All that means is that before you have a trial, they always set a final pretrial hearing. So I don't know if it's been saying that. It should have been saying that. What's up, Sleuthy? What's up, mods? Good morning. Look at all these beautiful humans. Mandy's like, "Oh, all of our West Coast subs are in here at 5:45 in the morning." That is amazing. That is amazing. You guys are beautiful humans. We thank you so much for hanging with us. So, yeah, again, today is the motion to dismiss going to be heard. Is Alan Jackson going to remain on the case? Is that going to be dealt with first thing? So many questions. Is Hank Brennan going to continue to sock? I mean, all these things we just need to know, and it's exciting to find out. So I like, I'll be stuck. Here's the way I'm going to play this. I will be completely stunned if Alan Jackson is removed from this case, but not surprised. Does that make sense? I'll be stunned, but not surprised if Jackson's removed from the case. If that happens, I'm telling you, there's no way this thing's going in April. There's no way. Even if the judge says, "I'm keeping the trial date," y'all have plenty of lawyers on that team. Y'all know the case. We're going April 1. As soon as they file either an interlocutory appeal or go to the Massachusetts Supreme Judicial Court, it's going to stay the case. Like in short of them getting that heard with a quickness, which they will expedite it. There's no question about that. But I don't know that they'll be able to expedite it in the fashion that would allow for this trial to take place on April 1. So, I mean, there's just a lot to find out today. We're gonna see it all. So, oh, well, hi there. There's Allie. It's the day before her birthday day.
Yay.
Yay. Yay, yay, yay. She was not aware that we were coming on at 7:45 our time. She was like, "Wait a second." She's like, "Why are you on at the crack of dawn?" I'm like, "It's East Coast, baby. It's East Coast. They start early for us. They start early." It's like there's so many East Coast trials and we stream so much East Coast stuff. It almost makes me want to move to the East Coast just to get an extra hour of sleep. Does that make sense? Or is that insane? That's insane, right? Um, so how y'all doing out there? Good? Good. All right, I think, did we decide we like Boston 10 or do we like Boston 25 better? I'm gonna pull both of them up just to see what's what. We don't have OnlyFans not up yet. All right, so pull this guy up. See what they got set for lives. Alright. I'm just gonna do Karen Reed hearing today. See what our choices are. I tend to think that the Boston news channels have better sound than the usual suspects. So, um, I mean, if there's nothing that I detest more than struggling with the sound during a live. Super annoying because you guys hear different levels than I do. Everything sounds fine to me. You guys are in chat. We can't hear it. I'm like, I, I've boosted it. It has been boosted. And it's frustrating. So hopefully we can find a there's a usual suspect. There's a usual suspect. Oh, we pop up. How nice. There's Mel. She's up. Her giant crowd. Uh Aiden's up. Melanie's got yeah, that's live now. Melanie's got Turbo's got 900 in there. Melanie's got 2600. That's funny. That is funny. Let me update that. Let's see. We have 169, but our 169 is the best, baby. That's all I know. Ooh, we got something. Shit's popping. Shit's popping. All right. So one thing that did take place is that we got OnlyFan chilling. One thing that did take place is that we got m- Eliza Little laying on the sword yesterday. She basically filed like a little affidavit, a little motion saying, "Hey, you know that whole payment thing? Yeah, that was on me, and like I was responsible, and we had like some clerk was doing it or some paralegal." So there was a quick laying on the sword yesterday, which I'm sure will be acknowledged today. Um, I'm having a catastrophic email issue with my computer. It's incredibly annoying. I haven't gotten an email on my computer since 3/1, but it's working fine on my phone. And I cannot figure out what the heck is going on. So it's really annoying. I'm basically now without my phone being connected to my Mac and my email, I'm like off the grid. Which I cannot be with my computer. I need my computer. I need to be able to get emails and things of that nature in order to be able to show them to you guys. Fortunately, I've got a partner in crime named Allie. Her shit all works proper. Oh, we got a we got a filing. We got a filing in Delphi. Andy has responded. Andy Baldwin has responded. 21 pager. It's a big one. It's a big one. Wow. See, there can't just be a day where I can concentrate on the one thing that I'm trying to concentrate on. Now I'm going to be trying to read this email and be trying to see what this filing's all about. What I'm sure it's going to be saying is he's going to be flame throwing Nick McClellan. That I'm pretty confident about that. Pretty confident about that going on. So it looks like we're right on the verge of getting this bad boy. So we're 7:56 my time, so that's 8:56 Easton. And big day. Big day. It's a really big day today. I mean, a lot of shit can go down today. Today is a big one. A big, big one. All right, let me see. Okay. Just gonna save that guy. Okay. So what are you guys thinking? Do you guys think we are going to have the motion to dismiss hearing today? I mean, that's a big hearing. Like in terms of like time, it's a long hearing. I would anticipate that it's going to be akin to uh Bob's, his kind of presentation that he put on the last time in court, which went 4.5 hours. I mean, it was lengthy. This this is kind of the equivalent. I mean, in terms of what it's saying. Man, I just you guys know how I feel about that. I mean, it should absolutely be granted. This case should go away. Like there is no cure for it. There's no cure for what the Commonwealth has done in this case. And frankly, the way that they proceeded in their first trial, see, because we all like, here's the thing about the motion to dismiss, it didn't really have anything new per se. We knew all of that. But what they finally did is they put it all together in one place so you could see in one place all the shenanigans that the Commonwealth was pulling. And when you see it all together, it's very compelling. And beyond being compelling, it shows that she was prejudiced in her first trial. She'll be prejudiced in her second trial. And there's no cure for it. I mean, a dismissal is the most extreme remedy. There is no more extreme remedy. Judges do not like dismissing cases. They just don't like it because it's so extreme. But if there exists no way to remedy the situation, and Allison's big on prospectively, how does it prejudice the second trial? I'm big on looking back and saying that there's got to be a punitive measure, a punishment measure for what they did in the first trial, because this whole like I cannot wait to hear either Brennan or whoever Brennan's going to put on the stand try to explain to everybody, including the judge, how all of those videos that they're claiming were inverted for the month leading into when that thing was tendered. The claim is, oh, all the cameras were filming shit inverted. So, okay, well, how do you know that? Because we know that you've already been in open court saying that all that stuff's gone, that it's all been overridden. So how do you know that, Hank Brennan? Like, we want to know how you know, because that's pretty mysterious, right? Seems like you shouldn't be able to know that unless somebody's full of shit. So I don't know. And let's not forget the thing with the inverted video is that the timestamp. Now, people that know way more about this kind of shit than I think have said that if you see the timestamp on an inverted video, that too would be inverted unless it was purposely put on to make it look like it wasn't inverted. Now, I mean, that would make sense to me, right? I mean, if a thing's inverted, it seems like the timestamp would be inverted, unless there was some tomfoolery, some shenanigans, some ballyhoo. I don't know. I don't know. But these are all questions that will be answered today. All questions that will be answered today. Yeah, yeah. We don't know yet, Liam. We're not sure. We are not sure what the protocol is going to be today. It's not clear. It's not clear from the docket just exactly what is going to be happening. I mean, no, we didn't find all we know is that's what Brennan's saying. And without any kind of receipts, without any chain of custody. Now we know that pursuant to Yanetti's affidavit last week that they were supposed to be providing, they being the Commonwealth, was supposed to be providing a chain of custody, which, y'all, I'm just trying to tell you. First of all, listen to my podcast if you really want to understand what a chain of custody is. We have these little things in my podcast, not on our Defense Diaries podcast channel on YouTube, but on our regular old podcast. I go through what a chain of custody is and why it is so important. It is everything in a case because it's the only way that everyone knows that the cops aren't messing with the evidence. If there's no chain of custody, they cannot prove it. And the days of everybody just trusting law enforcement with with everything that they do, those are long gone. Thank God. Like you guys don't even understand for 20 years of trying exactly. MB knows it's your favorite time. It's my favorite time. What is a chain of custody time? It's great. I'm telling you, you guys will love it. And you'll come away from it really understanding what a chain of custody is and why it's so critical. So in a situation like this, where we've now had this statement in open court that the DVR or whatever the hell the thing is that runs the cameras in the Sally port, that thing overrides after 30 days. You cannot create a chain of custody if you don't have that information, because you're not going to be able to show who accessed that system, who was doing what. Oh, is that what they're saying? They saved a video for a more important case from January 1. So that's what they have. Sounds like what they did to me is they just inverted another video so they could turn around and say, see, all the videos are inverted. Wow. Is that what they're bringing to the table? They're going to say they have a singular video from January 1 that's also inverted, and that somehow proves that all the videos were inverted. Wow. If they're going to, wow. If they do that, wow. That will blow my mind. That will blow my mind. My point being, they can't come up with a chain of custody after the fact. The whole point of a chain of custody is it has to happen contemporaneously. If a piece of evidence goes from one person to another, it's handed off, it's signed off by the person that's giving it over, the person that's getting it signs off. I mean, you could see it. Like when you see a physical piece of evidence, and you know that thing where they're sitting on the stand and they're unwrapping the paper bag, and then they're pulling out whatever it is, and it's in another evidence bag and there, and then they go through the process, and it's got the tape on there, and there's signatures on the tape. That's chain of custody. That's chain of custody. Exactly. This is a derp derble. Derp derble. Derp derble. Oh, see, Chelsea, you got Meg on the derp derbles all day now. I don't know if Meg had already derp derbled in here, but what I can tell you is she loves derp derbling. She's a derp derbler. Derp derble. Derp derble. Now I missed, did that come up from Dirt Devil? Like that little vacuum. Oh, we got movement. Exciting. I hear Allie moving about down there, so I think she's gonna be joining us soon. Soon. Yeah. Oh wow. Look, camera gals getting their swivel on, getting ready for the big action today. That's the equivalent of like warming up in athletics, doing your knee bends and your toe touches and getting your calves all stretched out. Oh, he's like, oh, little left, little adjust. Ooh, get a perfect look at that, just square on OnlyFan. So great. So all right, like last night, I realized I think I screwed up. I was listening, not by choice, it just popped up on my phone when I was driving Scarlett to the bus this morning. She's like, our live popped up, and I was talking about Sean from potentially criminal coming on, and I mistakenly said Wednesday. That is actually Thursday. Thursday. Like the schedule screwed up this week because Allie's birthday. So my wife's birthday takes precedent over everything. So and like I said, this evening we're getting time with the big kids and the grandchild, and then I imagine we're gonna do something uh on her actual birthday as well. So I told Sean that we're gonna, what do you need? There's one here. I don't know if it's a good one. It's a vape emergency, y'all. It's a vape emergency. Wow. There you go. Save the day. Save the day with her little cancer stick or whatever the fuck those things cause. I mean, I can't really talk. It's like I do the little pouches, which I really want to quit. Like I always have been trying to quit nicotine. Nicotine's the worst, y'all. I haven't smoked in a long, long, long time, but I've never really shook the nicotine. Yeah, Andy, it's kind of it's they don't it's like the bandits, but they've got there's no tobacco in them now. Now it's just, a nicotine vehicle. There's like Zin on all those different things. So yeah, like I worry about Allie's Allie's, golden pipes, man. Gotta worry about that. Like if you're creating and you have a podcast, being able to speak is pretty important. So I've been trying to lean on her pretty heavily about trying to wean off if possible. See, Sleuthy knows. Sleuthy knows. Like back in my smoking days, I would quit for a year flat out, not one cig. And then I'd be out at the bar, my buddies. This is back when people actually smoked in the United States. They still smoke like chimneys in Europe. It's crazy. And I'd bum one, just one. My buddies would be like, "What? No, dude. I'm like, nah, dude. I'm like, it's been over a year, bro. Like, I'm not gonna like one's not gonna like I'm not gonna start smoking again. And then, and I'd bum one and then I'd be like, oh wow, that was great. And then, the next time we go out a week or two later, whatever, Saturday night, I'd bum another one. And then it would turn into like two. And then, and then my friends would be like, all right, dude, I'm not bumming you anymore. You're like starting to smoke. So I'd go bum from strangers. Hey man, can I pay you 50 cents for a cig? And then sure as shit, within like a month and a half, I'm buying a pack. Oh, this pack will last me like months, and it would last a while. It just drags you back in every single time, super slowly. And it's insidious, man. It really is. It is an insidious thing. Like I quit drinking 5.5 years ago. It's cake. I realized alcohol is really, really tough for a lot of people to give up, and like my father included. The man cannot quit drinking. For me, it was like I was really lucky. Like I didn't need any kind of program. I didn't have any kind of like adverse, you know. Oh, there she is. I didn't have any kind of adverse, like really, like any kind of adverse impact at all. Like I just like I felt great so
From
quickly.
what?
I was talking about when I quit drinking.
Oh, yeah, I pretty much knew that right after I asked it.
Yeah, well, because I was talking about trying to get you to start weaning off the vape to preserve your. I love that, Andy. That's awesome. That's awesome. Isn't it awesome? It's awesome. I mean, that doesn't mean that I don't eat gummies and, I mean, weed's legal. I'm not insane. I just think that alcohol's absolute poison. I just do. And I loved drinking. Like I was a bourbon dude. I was a brown liquor guy. Like I'm a better husband since I quit drinking. Would you agree with that?
Yes, I
And
would.
I'm like a better everything since I quit drinking. It's like it was the best decision I ever made. Ever. Yeah, but I honestly don't really do the weed all that much either, right? I'm like
The weed.
the weed. I'm pretty sober.
I
Pretty
would
definitely
I
100%
would
booze.
disagree.
What?
You're
What
you're
is
100% alcohol free. California sober.
I know, but I'm just saying like I really don't do the weed that much.
I mean, yeah, it's true.
Yeah, I mean, like I have not been with I haven't been to the dispensary in like months. I still have that same one bag that I got from Emily for my birthday, which was in December. So there you go. Proof's in the pudding. And I think I have a half a gummy left because I only do 5 milligrams.
I could always tell when he does, he gets stupid.
I think I get super insightful.
You probably do that as well, but
Well, I just take longer to explain things,
yes, you
which
get slower. You get
I
slower. I'm like,
well,
"Wait a
you
second. Is
say
he
you
taking an
say
edible?"
slower, I say more in depth. Um, it's 23 pages.
What Delphi filing is 23 pages?
Andy is fired back.
Well,
If
I
only
do
I could.
think that we should stop this live, start all over again with the Delphi, call
No
it
way. Not a chance.
well, we
Not a
can't
chance.
we can't read a Delphi when we're scheduled for,
No,
Karen Reed. It's
that's
just
right. Our Delphi people, obviously we'll get the ride or dies will be there, but the straight up Delphi folks, they care not about Reed. It's much like the straight up Reed folks don't really care about Delphi. And ironically, y'all should be watching and following both cases because they're both uh, you
so
got
what is it, by the way?
it is
Oh, I'm gonna have to read it.
Richard Allen's verified reply memorandum to State of Indiana's response to preserve and produce and request. Sanctions.
Wait.
Kara sent it to both of us, so you got it.
We got it from the clerk too, I think. Yeah,
Yeah. Take a peek at it.
I am.
See if it's got some heat. All right. Let's see here. Yeah, I have a couple of friends that roll cigs, DJ Better. Like, not only do you save money, but I think that you probably smoke less. You know, it's because you actually have to put it. Even though my buddies that roll cigs roll them pretty quick, but it is a process. You get a little pouch, tobacco. Got to get your paper out, get it all out there. You know, that shit's harsh though. Without, well, you might roll it with a filter. I don't like. Wow, that's that is. I mean, Allie was a pack and a half a day.
I mean, I think it was a pack.
Nah,
Depends. If I
yeah, I
was
mean,
working on a filing, it could be 2.
yeah, it's true. And there were always the trigger times. It's like for me, it was after I ate. Obviously we weren't smoking in the house, but it was like back in the house smoking days. It was like sitting on the
Right, that
toilet.
was I smoked less, yeah, because I didn't smoke in the house. Now I just smoke wherever I am at any given time.
Well, I just remember that disgusting bucket, that butt bucket that we had in the garage that just like forever pissed me off. I'm like, that thing, like I knocked it over a couple times going out, and then like I'm like sitting there having to pick up like people's smoked butts. I'm like, oh my God, I'm gonna lose my shit. All right. Are you taking a peek at that thing? Like, I don't have my cheaters over here, so I'm
No,
like,
I
kind of,
was, but since it yeah, I am.
yes, like all often, all those times. Definitely eating, definitely driving. Like road trips, like that's back when, like, it's so rare to see people smoke in their cars. Like, I actually like I take pictures when I see somebody smoking in their car. Where was I just at? Where was I? Oh, God, down in Florida with like Prater smoking in his car. I'm like, what? I'm like, dude, are you insane?
Everyone we were with smoked in their cars. Prater, your cousin, your
Oh,
aunt.
yeah. Well, that's like, I'm like, no, man. Like, I like that shit. No. Like, can you roll your window down?
Eric.
Yeah. Well, he picked it up. Yeah. I mean, it's easy to chain smoke when you're driving because it really does. It's a good time kill and it keeps you awake.
That's why I didn't like taking the train to law school.
Yeah. It really impeded on your smoking time. Yeah. Oh boy, do we have some train stories we could tell, huh?
No. Wow.
Ooh-wee. That would cause so
I
did you
cannot believe you are total alright, move on.
listen, I love you.
I love you.
Did you see the awesome thing that Mandy did? I think it's so awesome. It looks like it's like an 80s, it's like a 1980s TV guide cover with you and I on it. It's like amazing. And it looks exactly like you when you were like a kid, except with your hair bigger. It like literally the picture that AI created like looks exactly like you from like when you were 15, like right around your bat mitzvah, like facially in your hair, like when you had that thing that you did with it, that little
What?
perm, that what was it? Like a perm. It was kind of big. You had big hair.
At my bat mitzvah, you're forgetting that Miriam chopped all my hair off.
Oh, is that when you did you had the feathered short do? It wasn't quite a bob.
Alright, now I gotta see what it alright.
Oh shit, we own. Let's go. Ooh, we hit 400 even. Hey, y'all do us a favor. Hit that like button on the way in.
Thumbs
We'll
up.
just, we love it. Just
Minimize the
smash
chat.
that thing. Smash it. Smash it. All right. Uh-oh. Of course, I have it on mute.
I was going to say, it looks like someone's talking, babe. That's all right. She's just doing her good
Sound
morning.
sucks.
All right, so we've got a few things to cover today.
All right, they're boosting it.
We had a couple of questions to finish off about the defense position on the opposition to excluding the ARCA witnesses. Then we'll go on to defendant's motion to exclude Mr. Crosby, Dr. Crosby, and then we'll go on to the defendant's motion to exclude Robert Gilman. I know they're both under dogget grounds, and we'll hear about that. And the Commonwealth's motion for sanctions. And we have newly filed a motion to amend the scheduling order so that we don't hear the motion to dismiss today, and in opposition to that, and a motion to reconsider part of my prior ruling regarding the tapes at the Canton Police Station video. So that's the order that makes sense to me to finish up what we already had scheduled last week.
Doesn't sound like she's excluding anyone or even thinking about it at this point.
So, the questions that I have.
Sure does not.
Before we start, so I want it to be very clear, council knows this. There has been some attempt at distinction between defense counsel. Mr. Yannetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you acts for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You all know that. Do you understand that, Mr. Yannetti?
I do, Your Honor.
Mr. Jackson?
Of course.
Ms. Little?
Yes.
And Mr. Alessi?
Yes, Your Honor.
So each attorney is legally accountable for the actions and statements of the entire team. So now the questions that I have, Mr. Alessi, that you said welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you call it. Could you stand, please, because I have to
Yes, I was going to go to the podium.
Sure, go ahead to the podium.
Thank you.
Can you stand,
I want to
please?
stand where you were talking.
You could stand. All right, so the pause email, as you call it. So first of all, we have that Wednesday, March 20th, 2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again, AJ. Then, as you pointed out, 2 days later, an email from Daniel Wolf to Mr. Jackson regarding Reed engagement, and that's the title of the other one. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it. Thanks, Dan. You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between ARCA and Mr. Jackson regarding compensation and retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring, or do you know that to be fact, that there was no conversation, emails, texts, letters, phone calls? Do you know that to be fact, or is that what you are inferring, as you said?
I am inferring, Your Honor, I do not know that as a fact.
Okay.
Ask your
So now my
co-counsel.
next question is regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time
Same time as what, Your Honor?
as the invoice?
And you're referring to the record of payment being?
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. Seems pretty clear. This was filed, I believe, in the weekend, February 16th. In the Commonwealth's opposition, defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense was not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just want to make sure you were finished with your
Go ahead.
question. I learned that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned.
You don't have
I'm
to
sorry.
repeat it. And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. And I want to, so I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through. And when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ARCA is signed by you.
Your Honor, it is signed by me, but if I could, with regard to 3.3A1, 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it, is in order to violate 3.3A1, the attorney in question has to know with regard to the fact and issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing in something that critical of candor to the court. That's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A from everything else in the world, which I agree completely with Your Honor.
All right, I'm not going to ask other counsel. All right, so let's move on to the next motion.
Your Honor, if I could, the tags that I had, I marked them as exhibits. I didn't do that last time. The white book, and I had marked. Mr. Brennan has agreed to them going. May I just offer them in at this time? They're all marked. There are two. Your Honor's February 6th was exhibit 1, so I picked off on 2 and worked it out before. What would you like me to do with these, Your Honor?
You can hand them to the court officer. We'll hand them to.
Well, there you are. Thank you. Thank you, Your Honor. And have you concluded what you?
I wish. Pause it real quick.
Okay.
Okay.
I don't like the answers here. I don't like the answer. I was inferring. What? You were inferring that there was no further conversation, then it was a surprise. And I mean, I don't think he was inferring that it was a surprise, but how could he have been told it was a surprise if he didn't get told that there was no further conversation about compensation?
Yeah, I don't know. I mean, he answered it carefully. Obviously, I mean, you want to hear a resounding no at that point. There's no question about that. The thing that I just can't get over is the way that Cannoni keeps trying to make any of the shit that happened after they did the work, they did the report and came up with their opinion.
That they're not neutral. She
They're not
somehow
that-
is
they're fucking
implying
neutral.
they're still
Period.
neutral.
They're still neutral. Not like none of what happened after the fact changes what their report said.
And I
Nothing.
honestly think that that's what their whole point is. Like when they're saying, I didn't hire them, I didn't pay them, this is a neutral opinion. This was their neutral, unaffected by the defense, evaluation, assessment, all of it.
They are not a hired gun. They are not a hired gun. We hire hired guns all the time, and they're hired guns that we shop for experts. But it's like you're looking for experts that will help your case. And if you find an expert, you're like, hey, don't write up a report. Take a look at this because, we don't want to have to disclose, which we don't have to. If you come back with an opinion that's not helpful to us, we're going to move on to another expert. Hey, man, sorry, this is what I came up with. Yeah, well, we're not going to use you. So there is that aspect of hiring experts that are absolutely hired guns. These two guys, Arca, were absolutely independent. I don't give a shit how she's trying to quantify it or qualify it. It doesn't matter. Their opinion was their opinion. And this is all like they're making a mountain out of a molehill.
Yes.
They really are.
Neutral. No matter what way you cut it, they're still neutral.
Their
opinion is still neutral. Their opinion, their findings.
Right. Exactly. And like Brennan's whole argument that, well, once the defense saw that they came down on, the side of essentially the defense because it would be helpful to them, they no longer were neutral. Yeah, they are. They're still neutral.
Well, their opinion is, which is all that matters.
Which is all that matters.
So I agree. I don't know why the judge is acting like the way she enunciated neutral, as though that's not the case. But as I've said before, there is still something. I do still think it is helpful to the prosecution and worth noting that the witness is like, I'm not going to say that if you don't want me to. Although I have said time and time again, it wasn't like substantively pertinent to their findings, but it did show their willingness to, you know, to follow the defense's lead on certain things. Whether it doesn't matter, it didn't come to fruition. The defense put it out there anyway. But I do think that that is something that they could have put in to try and make them seem less neutral. But at the end of the day, as you've said ad nauseum, their findings, their opinion, their examination was all neutral.
All neutral. You know, I mean, she can make her findings, and you know what? She can fine the defense $1,000. Let's call it a day. Like, you know what I
Nonetheless,
mean?
I'm just going to say I wish that they were answering this more directly. I wish it didn't feel so, like
Slippery,
slippery. Yeah.
right? Yeah, I don't understand it either. Because when he answers it like I'm inferring it, it makes it sound like they're trying to hide something. And
Right. Like she's asking, did you directly ask this question to your co-counsel? That's what she's asking when she says,
right.
did you infer it or is it a fact? Now, maybe, although I don't see it, he's saying, well, I have to infer it because I don't know it personally, but that's not what she's asking. Do you know this for a fact? Did you ask it of your co-counsel?
Yeah, I mean, like, look, we all know, all of us have seen enough of Bob Alessi to know he's the smartest guy in the room here, like, bar none. It's like this guy is like super genius, you know, like the guy's a brilliant lawyer, and there's not a chance in hell that he didn't sit down with Alan and David and say, all right, like, did you talk to these people? You know, like you can't put me, so it's like that's a little worrisome. It's a little
Yeah.
worrisome.
But I'm going to stand by and wait for her to direct a similar question and statement to Brennan.
Yes.
You know that I don't care that you weren't here at the first trial. You can't just say things. You are responsible for the words, even if you weren't there. You speak for the Commonwealth that existed at the time when you're speaking about what the Commonwealth at the time did.
And your little buddy Lally's sitting right next to you.
And what the state did. You're speaking for the state now, just like Alessi is speaking for the defense then. He's speaking for the state then, and he better know that what he's saying is accurate.
100%. What's good for the goose, it's good for the gander.
All right. So let's go on to
One more thing, sorry.
No, thank you, Your Honor.
Babe, one more thing.
So let's go on. I don't have Jim.
What?
Just one more thing.
Okay.
Although she is not willing to direct questions at the defense, because in her mind, she still thinks they might be implicating themselves if she asks them directly. That's what I think. Nothing prevented the defense from standing up and saying, Your Honor, I'd like to speak on this. Nothing.
Right. 100%.
When I say the defense, I mean Alan Jackson,
yeah,
and Yannetti.
Well, and I know for a fact if you and I were sitting in that courtroom and we had the position and we knew what was what, there's no way we wouldn't have been standing up saying, well, Your Honor, I'm going to chime in here.
Right.
No, I
And
never,
I'm sure
I
she
never
would-
spoke to these guys.
There's not a chance in hell that she'd say, I don't want to hear from you. She just said, I'm not going to direct questions at the rest of the defense.
Correct.
499. So the motion of the defendant to exclude the testimony of the Commonwealth's witness, James Crosby. And I've read it. I read it 2 weeks ago when it came in, Mr. Alessi. I'll hear you on your motion.
Thank you, Your Honor. I'm just getting myself reoriented
Take your
back to
time.
it. Thank you.
Yes, we are.
May it please the court.
The entire proposed testimony of Dr. Crosby should be excluded because he is plainly not qualified to render the opinions that he is trying to render, and his methodology not only is not reliable, but it's not even documented. Your Honor well knows the inquiry under Dalbert Lanigan, so I won't go through Rentala and the rest. Your Honor's heard it many times before. Under the qualifications prong, the crucial inquiry, Your Honor set the standard for the subject matter of his testimony. And what is the subject matter of his testimony? The subject matter of his proposed testimony is the medical cause of the injuries and wounds to the right arm of the decedent. I'm going to get into how Dr. Crosby tries to camouflage to avoid the impact of the standard Your Honor established. But that is clearly what he is trying to do. And I cite to NDAO 1377, NDAO 1382, because that is where he renders his opinions. For example, he says, this is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe. Similar statements. So it's very clear that's the subject matter of his testimony. Your Honor stated with regard to Dr. Rentschler that it is clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury, the key point. Only an MD can do that. That's what Your Honor said was the clear law.
What's good for the goose, it's good for the gander.
Admittedly, indisputably, Dr. Crosby is not a medical doctor. As a matter of fact, Dr. Crosby is not a veterinarian. He's not a forensic odontologist. And those are all disciplines that can even get near the type of subject matter that he's looking to opine about. He tries to dodge that very impactful standard that Your Honor established by saying, well, you know, this case is not about the treatment of the decedent. It's not a case about the treatment of the wounds on the right arm. And yeah, you'd have to be a medical doctor to treat, but that's not what the issue is, so I'm okay. It is a total straw man argument. He's creating this treatment. Nobody ever said the way that the issue is treatment. Dr. Russell never said treatment. Dr. Crosby made it up. So he creates this straw man to try to avoid the medical causation opinion that he is given. And I think that's a clear indication that he is very, very sensitive to the issue that he's not a medical doctor. With regard to his area of expertise, it can't be more obvious than his own proclamations. He says the name of his consulting group is Canine Aggression. His purported title is Certified Behavior Consultant. So he himself dubs himself with regard to canine behavior. And that is what he is expert in. And of course, there's no issue whatsoever in this case about canine behavior. And more importantly, his own report doesn't discuss canine behavior at all. So in conclusion, on the qualifications prong, Your Honor, based upon Your Honor's standard, he's not a medical doctor. He's therefore not qualified to opine on the cause of the wounds to the decedent's right arm. The court need go no further than the qualifications prong to exclude all of his testimony, because all of his report is regarding the cause of the wounds to the decedent's right arm. And it almost is common sense that when someone is trying to opine on the cause, the medical cause of injury, that if you're not a doctor, with regard to the issue, that you're not qualified. So now let's go to the methodology of Dr. Crosby. His methodology is essentially, he took measurements of one dog, a dog named Chloe, that it purports to be Chloe. He didn't document that it was. There's no documentation of that. But let's assume, hypothetically, it is this dog Chloe. So what does he do? He takes measurements. This is what he did first, and I'm going to get to what he's just recently submitted. So what does he do? He takes measurements, anesthetizes the dog, takes measurements of the teeth, and then he takes those measurements and he tries to apply them to photographs of the decedent's right arm. And he basically says in his methodology, I am measuring the distance between the canines. I'm taking other measurements of the dog's dentition. And then I'm going to compare them to the decedent's right arm in a photograph. And I am going to opine that the measurements of the dentition don't match up with the measurements and distance of the wounds on the right arm. Therefore, this dog couldn't have caused these injuries, and therefore these wounds are not caused by a dog. And this dog, so he says not only not Chloe, but no dog. Then he goes even further and he says, and I believe the cause is some sharp object. So now we have him going even beyond a dog, and he's claiming that it was caused by a sharp object. It just goes to show you how far he is afield of what he is doing. So he's not a medical doctor, so he's now performing essentially another diagnosis of the wounds to a human. He provides zero evidence of any experience in determining whether a wound on a human is caused by a dog or a sharp object. And his methodology, Your Honor, is remarkable for several other reasons. First, he uses a hospital wristband to take his measurements because the photographs of the autopsy didn't have the ABFO ruler in them. So he tries to use the wristband as a surrogate for his measurements. He provides no support whatsoever for using that surrogate. And what do I mean by support, Your Honor? For an expert to justify a methodology, they've got two ways to do it. The most prominent and common is that the methodology is generally accepted in the relevant scientific or medical field. He provides zero, and I mean zero, words to tether his methodology to a commonly accepted practice, meaning his methodology that he used, he doesn't show any support for that at all, let alone it's commonly accepted. He doesn't cite to one study. He doesn't cite to one scientific publication that says this is a permissible way to determine whether a bite is from a dog. So the burden, as Your Honor knows, is on the Commonwealth to establish the methodology. And I note, Your Honor, that the Commonwealth, in its first response, states in the third paragraph, Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm. What recognized methodology? Where is it? It's not in his report, and it's not even in the opposition. So they try to brush over with a conclusory statement, Dr. Crosby engaged in recognized methodology, when it's nowhere in their opposition. Where's the recognition for it? That dooms completely their second prong of Daubert. Then what they say about methodology in the same paragraph, they say the methodology employed was based on facts, science, and study. What do they cite to? They cite back to Exhibit 1, which is his report, which has not one footnote, not one reference in his report to support it. So the statement the methodology employed was based on fact, science, and study is a bald conclusion with no support at all. And this was the opportunity for the Commonwealth. I put it pretty clearly what the challenge was, for them to come back and say, oh, no, the methodology, it's recognized, and here is the basis for it. It gets worse for the Commonwealth, Your Honor, on the methodology, because there are potentially some methodologies that might be used. They're called into serious question, but one of them for humans, not for dogs, is what the ABHO talks about is the dental mode and overlay method. And that is basically take a mold of dentition, and in the most recent submission, the Commonwealth put in very belatedly, but I can deal with it, that Dr. Crosby now says he took molds of the dog's teeth. And so I'm going to accept arguendo that he did that and he did it correctly. But what he misses is those molds are meaningless unless you come to part 2. You've got to take those molds and compare it to something. And the something is what's called the overlay method. And what is the overlay method? And this is all set forth in our opposition. And I've got citations to the exhibits, which I'm going to go to. The overlay method is the part 2 you apply the mold to. So what you do is you take tissue samples of the wound and you make, there's a variety of techniques you can do, but you basically create the wound on a model, and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part of what is, even with 2 parts, is a questionable methodology. He doesn't employ the overlay method, the part 2. So the molds that he took are meaningless unless you have the overlay to go with it, because that's what you compare them to. More important, HO makes it clear that the only people that can do that are forensic odontologists. People that can do that are forensic odontologists.
Yeah, what's going on? We got a little glitch here.
And even
Glitch in the
then,
matrix.
science is very questionable. What he also does in terms of, and also for his methodology, where it's just a measurement, he provides 0 citations, and the Commonwealth provides 0 support for taking measurements in molds and comparing them to the wound. 0. So what are the other errors of Dr. Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that
They put an
Dr.
affidavit
Crosby
in their opposition.
caused in his
Novel.
analysis. The
Novel.
first, she says, is that he treated the arm of the decedent as if it is a static, plastic mannequin-like object.
That's what I was going to say.
What is meant by that? Your Honor may recall Dr. Russell stated that when anyone is attacked by a dog, they move their arm, they flex their arm, and they move it, etc. And that can cause a dog's teeth to have an incomplete bite, etc. Dr. Crosby doesn't account at all for that movement. So what he did was he treated the arm as if it never moved, and then he said, I'm going to take the dog's teeth, measure it, and then I'm going to take those measurements to a static arm.
As though skin's not
He says
elastic.
just the distance is too far off to say that it was from any dog. Well, what he didn't account for is that when the arm flexes up, as it always happens in the defensive wound mode, those angles and those distances change. They get closer together. It's common sense, but it's also medically supported by Dr. Russell. And she said when you do that flex, that is going to make those wounds approximate the canine. But the fact is, her main point is he never accounted for that in his methodology. It's not an opinion. It's a methodology. So it again, if he were to cite to a study that would say, no, it's okay to just treat it illogically as a static object, he might have some support, but he doesn't, and there is nothing in the literature because nobody believes that's at all realistic in a dog attack. So that's her first criticism of him. She also states that the photos that he used, there's no documentation of who took them, how they took them, and we all know in forensic photography, those people who take those photographs have to be trained. They have to give a fair and accurate depiction. And you can look at one of the key photos, it's blurred. So it's obvious that there's a problem with one of the photos. She also aptly points out that there's not one citation in his report to any support for anything that he did. The Commonwealth, in their opposition, spent more words going back trying to attack Dr. Russell than they did trying to support their own expert's opinion. And I just counted the lines. I'm not going to tell you what the count is, but there's more lines basically trying to say that Dr. Russell's entire testimony and opinions lacked adequate authority. My. She had, I think, 31 footnotes in her report. The one who entire opinions lacked adequate authority is Dr. Crosby. The other criticism that she has on the methodology of Dr. Crosby is that he didn't account for the dimpling and pinching and piercing of skin, human skin. When there's any pressure, particularly with a bite, it moves, it dimples, it hits the muscles, etc., etc. He gave no account for the condition of the human arm and skin and anatomy, perhaps because he's not a medical doctor and doesn't know the area. So with regard to the Commonwealth's response, I'm appreciative of the fact that they cited to his thesis. So what they say is in the second paragraph, they said his master thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer reviewed. So what did I do? I went and read both of his theses. What I found is particularly probative of the issues I just raised. So I looked at his and read his. I read 179 pages of his 2016 Master of Science thesis that they cited. In it, he talks about, on page 46, defining bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them. And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern. A dog bite injury is a pattern injury. So I appreciate in his thesis that he confirms Dr. Russell's methodology. What he doesn't do in his thesis is even mention his own methodology that he used here. In 179 pages, there is now one reference to the methodology he used in his report. With regard to, I mentioned the ABFO, the American Board of Forensic Odontology, and I mentioned how difficult that is to do that correctly. In his thesis, he states, and I quote on page 61, the guidelines, however, do not indicate the criteria necessary for using each method to determine whether the bite mark can be related to a person's dentition and with what degree of probability. There is no science on the reproducibility of the different methods of analysis that lead to conclusions about the probability of a match. A very, and I couldn't agree with Dr. Crosby more on that. He then talks about, in his thesis, about the fact that there's no accepted methodology for dog bites, even using ABFO. And on page 63, I'm going to quote what he says. Although the ABFO does not specifically address animal bites, it would be logical to apply the same standards to forensic examination of dogs. And what is that standard? That's the mold in the overlay, right? He never did the overlay, and he was proposing in his thesis that that might be a way to go, but he recognizes that it is not reliable. And then on page 66, the last paragraph I'll cite in this, he says, reliability in human cases is under examination. Hard statistical agreement on consistency is not present, so each evaluator will have to make the best argument in each case. As case law develops and examination science progresses, we can hope that standards will be established and accepted. Until then, a forensic bite evaluator can best develop their opinion based on whether the bite mark in question is consistent or inconsistent with a pool of potential subjects established by other means. Here we go. This opinion should be heavily influenced by supportive hard evidence, such as DNA, physical observation, blood, tissue recovered from the gastrointestinal tract, and other factors. So the ABO, he agrees with the fact that you just, even with this methodology, you've got to have it supported by this hard evidence that he doesn't have anywhere near in his methodology. And what he also talks about is relying upon a medical examiner for this hard evidence. And what we point out in our opposition, Your Honor, he never worked with a medical examiner for his methodology. He never worked with a forensic odontologist. In the case law that we point out, even in this very suspect area of bite mark analysis, even in the cases that allow it for humans, they are all cases where there had to be a forensic odontologist or a medical examiner involved for quite obvious reasons. So his master's thesis supports the methodology of Dr. Russell and provides not one mention of his methodology. So then I said, well, maybe in his PhD thesis, which is more recent, 2023, maybe in that thesis that the Commonwealth did not cite. So I went and read 143 pages of that, and there is zero mention of his methodology, and that was just 2 years ago. So what does he say? In his whole thesis is entitled Dog Bite Related Human Fatalities in Scientific Study. So it's really about fatalities, and here it's undisputed that the decedent, his death wasn't caused by a dog. It's a dog attack, but that was not the cause of death. And his whole thesis is about the problem statement. He defines his thesis on page 18. One of the problems is the lack of standardization of methods in reporting. Lack of standardization manifests in several ways. So basically what he did in his thesis is he went through and talked all about when there's fatalities, there's ways, and he creates a classification system on page 63. but his classification is on behavior. Second sentence, page 63, classifying dog bites. This provided the opportunity to develop a protocol for classifying the incident from the dog's likely perspective based on its behavior. That's his thesis. It's got nothing to do with, is this wound caused by a dog bite? And so on the point of needing a medical examiner, needing someone like a forensic pathologist to be involved, he agrees. Page 125 of his PhD thesis, first full paragraph. Where possible, medical examiners or other examining experts should document the location, extent of wounds, and try to determine which wounds may have been antemortem, perimortem, postmortem. This may require histological analysis by a forensic pathologist. So he mentions what medical examiners should do, what a forensic pathologist should do. He doesn't even begin to suggest that he should do it or that he is even qualified to do it. So in sum, Your Honor, with regard to Dr. Crosby, whose degree is in veterinary science, I don't know what that is. Dr. Russell doesn't know what that is. It's certainly not a veterinarian, although if one reads it quickly, one might think that's what it issued. He's not. He was a police officer for 22 years. And even then, he didn't deal, he wasn't like a canine police officer. He had an interest in them then. And it wasn't until he retired that he became active in dog behavior and how dogs behave, if they're aggressive, et cetera, et cetera. So why is it, Your Honor, that we respectfully submit that he cannot testify with regard to the subject matter of his report, which is the medical cause of the wounds on the decedent's right arm? He's not a medical doctor. He's not a forensic odontologist. He's not a veterinarian. He has none of the qualifications to do that. And he surely doesn't have any qualifications to say it wasn't a dog, but it's a sharp object. And then with regard to his methodology, he doesn't document at all how that methodology is generally accepted. He doesn't even, nor does the Commonwealth even talk about the non-exclusive Daubert factors and how they might satisfy that alternative. And lastly, when he speaks and writes a master's thesis and a PhD thesis of just 2 years ago, he doesn't even mention the methodology that he used. So, Your Honor, in Your Honor's opinion about Dr. Russell, stated that it was a close call for Dr. Russell in her ability to testify. If it was a close, no, not if, since it was a close call for Your Honor, I believe it is as distant a call as possibly could be made with Dr. Crosby. So I respectfully request that he be excluded. There's no need for a Daubert hearing. It's plain on the papers, and it's not something that is curable. The Commonwealth tried to submit very recently a mold. Interestingly, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had 2 tries at it, and they haven't come close, and I'd urge the court to reject it. A jury should not have to hear from a dog behavioralist on what was the cause of the wounds to the right arm of the decedent.
All right, thank you very much. Mr. Brennan, before you begin, Dr. Crosby is not going to testify that this injury appeared to have been caused by some sharp object. You plan on bringing that in?
There you go.
Ask him to do that, no.
All right, so I'm moving on.
Yeah.
Yes.
Mr. Releasy tries to point out differences between Dr. Russell and Dr. Crosby, and there's always going to be differences between experts. One difference is that Dr. Crosby has actually testified in state and federal courts regarding dog bites before, where Dr. Russell never had before this case. And so in preparation for Dr. Russell, we provided not only a CV, a history of his education, but also an actual report. An actual report of what Dr. Crosby did, the methodology explaining his analysis, his examination of Chloe, and his testing. And that was provided to the defense prior to any testimony that he will have on the stand. When we look at the summary that's provided, Dr. Crosby has testified in numerous cases before. So those courts seem to disagree with Mr. Alisi's opinion. In addition, Dr. Crosby set out in his package numerous different journals and publications that he relied upon in this case. There are a number of publications, I won't read them all to the court, but we can see that he relied on books regarding bite mark evidence, human bites versus dog bites, forensic study of dog attacks on humans, a focus on bite mark analysis. The list is comprehensive. Variable mechanisms of dog-related deaths, life-threatening dog attacks, a devastating combination of penetrating and blunt injuries, fatal and near-fatal animal bite injuries, on and on. These are materials that he has studied, he's familiar with. Dr. Crosby has the qualifications to testify, not simply because he's testified in state and federal courts before this case, but also because of his studies and his education. It seems as though Attorney Alisi is trying to bind the court regarding a comment of the necessity for a medical doctor. There is no requisite that an expert in this field needs to be a medical doctor. There is no cases that they provide that bind that limitation. The qualifications of Dr. Crosby are outstanding and significant. He studied at the College of Veterinary Medicine. He completed coursework in forensic animal behavior analysis, animal crime scene, bite mark analysis, veterinary forensic pathology, forensic crime scenes. He is often called to go to autopsies around the country to study wounds and determine if they are bite marks, if they are dog wounds, and if they can be attributed to a particular dog. He served as acting chief.
Is that in the papers?
The different autopsies he hasn't, I can supplement the autopsies he's been to, and I can also supplement specific cases where he's qualified. He has listed a number of cases in the back of his package.
So do I have the exhibits that I have are attached to the Commonwealth's, the defendant's motion?
They
So
have-
I don't know that I have all the reports.
Exhibit 1 has
Okay.
Dr. Crosby's report that has all this information in it.
Okay.
And as I mentioned on a previous tape, Dr. Crosby actually went and examined Chloe. And when he did that, he verified that it was in fact Chloe. He did molds of Chloe, and there was a subsequent report regarding those molds, which clearly demonstrate that the distance in those wounds are not anywhere near consistent with Chloe's spacing in his teeth.
So sort of as an aside, based on what Mr. Leslie argued, the verification that it was in fact Chloe, has the Commonwealth provided that information to the defense?
We have, and we can provide that as a supplement to the court, the verification of Chloe, and we can also provide to the court the bite mold analysis report of Dr. Crosby, which is not in
I
this
have
package.
that, I think that's attached here, I have the photographs.
That's part of the original report, but then he actually took a mold of Chloe's jaw and teeth, and then I asked him to supplement a report regarding the mold.
And that's been provided to the defense?
It has, but it's not been provided in this package, so I can provide that to the court. So I'll supplement those two different items for the court's reference. In addition to his experience, he was chief of animal care protective services of the city of Jacksonville. He had oversight and approval of criminal investigations. He trained staff in dog bite and dangerous dog investigations. He served as the Animal Control Division Manager for Bay County, Florida from February 2008 to 2010. He has training and experience, including certifications in humane euthanasia of animals, legal restrictions of methods and reasons for euthanasia. He's investigated numerous complaints of dog bites, and dog behavior. He's published. I had shown the book to Dr. Russell when she was cross-examined. He has a number of engagements where he teaches. Dr. Crosby is well recognized in the field. He has employment in other projects other than his business. It includes a research associate, Canine Brain Project, 2023 to current. It's associated with Harvard University. Duties include the investigation and documentation of dog bite and related human fatalities. Also, division management consultant for Animal Care and Protective Services, City of Jacksonville in 2016. He is a professional dog trainer, behavioral consultant. He has provided expert witness testimony in cases of dog bite, dog attack, dog-related fatalities. Now, in Dr. Crosby's report, he outlines his methodology, and you can see it is specific, it is detailed, it is consistent. So when we compare, I'll refrain from getting into too much of a comparison. When we see the actual study of dog bites, we see something different in Dr. Crosby's report. They're not unsupported claims that change from time to time. You can see that there are the pictures of Mr. O'Keefe's arm, and we can see the band in which he used to measure. You can see multiple pictures of Chloe's jaw, mouth, teeth, canines, incisors, and then you can see that he has measured the distance of all of those teeth specifically. And then in his methodology, he outlines each group of lesions, specifically lesion group 1, lesion group 2. And then he goes into an analysis of the different groups of lesions. He explains why they are wholly inconsistent with both a dog bite and any animal bite. And he also describes and explains that the distance between the wounds are totally dissimilar to Chloe's mouth. He does look, as Mr. Alisi suggested, at other support, such as DNA. And in fact, he embraces other support. In this case, there is no canine DNA, significant to Dr. Crosby because in virtually every case, he finds canine DNA. So he does look to alternative sources, and mindful, there was pig DNA found. So it wasn't as if the sample was obliterated or destroyed and there was no materials available for testing. It's just the unfortunate consequence that there is no animal DNA. And so while there are different methods, and some of the things that Attorney Alisi spoke about, dentition, deal with human biting, not dog biting, his methodology is set out very clearly on how he came to these determinations, what he did in his study. He actually engaged in an investigation in this case before providing his opinions. So Dr. Crosby is well qualified. He has been accepted in state and federal courts before this case. He did a thorough examination. He has ample support for his training and experience, and his opinions are soundly based, not on hypothetical or rhetoric, but on the facts, on the details in this case. He has never changed his position from one event to another. It has always been the same in this report, has not wavered, and he is highly qualified to appear in this case in rebuttal if necessary, if Dr. Russell is to take the stand and provide some or any of the opinions that she provided before.
All right, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief?
Absolutely not.
Okay. All right, Mr. Alesi, any follow-up?
Thank you, Your Honor. Thank you. The Commonwealth did not address in its presentation, you heard, one probative, legal, or factual point I made because they can't. Specifically, the Commonwealth just stated that Dr. Crosby has testified in court numerous times. On what? It's important. You can be qualified to testify, and if it's what Dr. Crosby does on behavior, dog behavior, was the dog an aggressive dog? I get it, but the Commonwealth never said that in even one of those cases, Dr. Crosby testified on whether the cause of a wound was from a wound to a human was from a dog. Wasn't mentioned. There's no case provided. As best as I could, I looked at those cases. I couldn't find many of them but I didn't see any indication that he testified and was allowed to testify that the cause of this wound on a human was from a dog or a specific dog. Point number two, Mr. Brennan mentioned he cited numerous journals. Your Honor, I would ask the court to take a look at his report. There is now,
Hold on, so that's
Yeah.
exhibit one. If we
yes,
know-
exactly.
Just give me a minute, just put them back in. All right, so what page?
Every page. The point is, there's not one footnote in any of his reports. So he does go through his purported methodology. I've never said he didn't present a methodology. My point is, his methodology is not accepted, let alone generally accepted, and nowhere in his report does he say this methodology, this measurement methodology, is accepted at all. And you have to either show in Dalbert Lanigan that either your methodology is generally accepted in the relevant medical community, or that you can satisfy the Dalbert factors, which I'm going to get to. But Mr. Brennan said he cites to numerous journals. Your Honor, this is what Mr. Brennan has to be referring to. If Your Honor would please turn to the end of the report. This starts on NDAO 1400, very much toward the back.
Okay,
So he's got it in alphabetical order. Importantly, the page before 1399 at the bottom is entitled References and Materials Consulted That May Affect My Opinions in This Case. You can't have an expert report that does a data dump of references and says, there might be something in here that I might have considered that might affect my opinions in the case. And that's exactly what he did. And the only conclusion I draw from this is his methodology isn't in any of them, because if he had to cite which one of these contained his methodology, he would have to be creating fiction. So when Mr. Brennan says he cited numerous journals, well, he did, but where does he tether his methodology to one of them? He doesn't, because he can't, because his methodology, to the best of my research and Dr. Russell's, has never been accepted by anyone. So then what Mr. Brennan stated was that he participated in autopsies. My point exactly. He participated in them. He obviously doesn't perform autopsies, so it had to be with a medical examiner or forensic pathologist. He didn't do that in this case. There's no statement by him that he worked with a medical examiner, etc. So I think the inference the Commonwealth wants Your Honor to take is, because he's participated in autopsies, he must have been the one that determined whether or not the the wound is from a dog. There is zero evidence in any document from which even an inference can be taken. There's no foundation fact from which the inference can be taken that that's what he has done. He mentions a book that he tried to use on Dr. Russell and for whatever reason immediately truncated it. I will just reference that book is not peer reviewed, but importantly, nothing in the book that Dr. Crosby wrote, and I thank Mr. Brennan for bringing it up, there's nothing in that book that sets forth the methodology that he used here. It's not there. With regard to he's well recognized in the field, that's exactly what Mr. Brennan's words he just used. He's well recognized in the field. What field? For Dalbert, you gotta have experience in the subject matter. I don't know what he means by field. Is it dogs, dog behavior? In Daubert, it's the subject matter, the testimony, which is what's the medical cause of the wounds to right arm. That's not documented. That's not even stated. He mentions Harvard, which people use for obvious reasons. You know, it's Harvard, but what is it that he is participating in Harvard in? This was from the words of Mr. Brennan, canine brain behavior. I didn't hear anything that he's at Harvard opining on the cause of wounds to humans and whether they're not from a dog. Mr. Brennan said that he outlines his methodology. I agree with Mr. Brennan on that. He does outline the methodology that he uses. But fatal and problematic is he doesn't tether it to a study to say it's generally accepted, which is the key inquiry under either Commonwealth v. Davis, common acceptance, or the Daubert-Lanigan, the 9 exclusive factors. And then the last point that Mr. Brennan made is particularly telling. He said Dr. Crosby bases his opinion on facts. That's not the Daubert inquiry. You've got to base your opinion on a reliable methodology. Facts, yeah, they are somewhat relevant, but the most probative aspect is methodology. So I am still, after all this time we've argued this, waiting to see where is the study, where is the documentation that the methodology that Dr. Crosby used, that a medical doctor, Dr. Russell, so thoroughly criticized, where is that methodology documented in one of these many references at the end, no footnotes in his study? I believe, and why isn't it, Mr. Brennan didn't respond at all to my points about Dr. Crosby's 2 theses, where you would expect his methodology to appear, and it's completely absent from there. So the question is, in conclusion, where is the home for his methodology? Where is the home? Where is the home in the scientific literature? It's an orphan methodology. It has no home because it's not generally accepted. So he is not qualified under Daubert-Lanigan, and his methodology is an orphan. And for those reasons, not only can he not testify with regard to whether the cause is a sharp object, but he has not, the Commonwealth hasn't even begun to meet its burden that his methodology is reliable for all the reasons that I have stated. And a good part of my position is based upon Dr. Crosby's own report that doesn't tether it to a study or general acceptance, and Dr. Crosby's own theses that don't even mention the methodology that he is trying to put forth in this case.
Okay. Anything else, Mr. Brennan?
Briefly. On page 6 and 7, Dr. Crosby offers court cases in which he has testified and provided expert opinion. I will give you specific cases where he's been qualified in state and federal court. Mr. Lisi harps on the idea of methodology. If we remember Dr. Russell's testimony, it wasn't until later in her testimony that she introduced this idea of pattern recognition analysis. And we hear very little about the details. What we knew or learned from Dr. Russell is that she couldn't identify any of the wounds, none of them independently, just collectively. In fact, I think she opined that she was the only expert in the country that really could perfect the art of pattern recognition analysis. Attorney Lisi's arguments are the fact that he doesn't like the way Dr. Crosby wrote his report. But what I can say for Dr. Crosby is at least he wrote his own report. And when you look at Dr. Russell's affidavit in support, there's something, to be intellectually honest about it, striking. Kind of like her original report, where it was clear to me that it wasn't fully written by Dr. Russell. You look at that affidavit, it is not consistent with the testimony or the mannerism or the way that expert speaks. And so a lawyer can craft an affidavit and help craft a report so it meets their idiosyncrasies, but that is not the arbiter if somebody's qualified. Dr. Crosby is qualified, he has experience, he's testified and been accepted by courts before. Thank you.
Okay. So before we move on to the next motion, the next motion was, it was filed after the other motions that
Babe, pause it a sec.
we finished here.
I don't understand why why they're not having evidentiary Daubert hearings. Like,
Well, I mean, at least he was arguing that they don't even get to that. Like that on the papers, this guy, so Judge Cannoni had already ruled that, you've got to be a medical doctor in her court in order to do that. And he's saying this guy's not a medical doctor, so like again, what's good for the goose, good for the gander.
no, I absolutely agree with that. It just seemed like,
I mean,
'cause
Hank does not provide any actual answers. He talks and talks and talks and talks and never, ever actually responds to anything that Alessi ever says. It's
I
crazy.
know, did he ever say what he had been admitted as an expert in other cases?
No, he
Just that,
never answered any of that. When he stood back up for the second time, he still never answered any of that. He does not, he never never provides receipts ever under any circuit. He just says shit. That's all he does he says shit. I'm going to get up there and I'm going to say some shit. And, I'm going to have this tie on with a really bad Windsor knot.
all right. But I just want to point out,
dude, I'm sorry. That tie.
I just want to point out that when Lally complained about not having enough information in the reports or not being able to discern methodology or who did what, the judge was like, yeah, this isn't enough. We're going to have a voir dire. Like, how come she's not saying right now, can you tell me when what was he admitted? What type of expert was he admitted as, accepted as an expert in what fields? Like, why is she not asking any follow-up questions? So maybe I missed it. Did Alessi say, and if you don't find on the face of the pleadings alone, then we need an evidentiary hearing?
No, I mean, his argument is that this doesn't reach the level of requiring a full Daubert. I mean, that was his argument. It should never get there. This guy's not qualified.
Or well,
He's not even
hopefully,
qualified enough to require a Daubert to challenge his methodology. Because at first, when Alessi first stood up, he said that he didn't even that Crosby didn't have, or Crosby, they both called him Crosby, that Crosby didn't have any methodology that he used. And then Brennan stood up, made words, and then when Alessi got back up, he's like, oh, well, all right. He kind of acknowledged that he had some kind of methodology, but that it wasn't real. So
right. So, but that, once you get to that, whether he has the ability to use the hospital bracelet as a measuring tool to convert some, like all of that, and that the skin moves and this and that should have all been done with the guy on the stand. Did you account for this? How do you account for that? I don't know.
but that's a full-blown Daubert.
Well, right. So that's why I'm hoping he's asking, if you can't decide on the papers, then we want a full-blown Daubert. Do they not want a full?
Or at least a voir dire?
Well, I mean, I'd be asking for a full-blown Daubert hearing.
What if you're the defense? You don't even
After this, I guess, or in as the alternative. And if Your Honor doesn't find that he's precluded on the face of his, on the face of his report, as the law of the case in Your Honor's previous rulings, which it seems like she did say, he's not going to be able to say this was created by a sharp object, right? She squashed that right away.
It appeared so.
Right. So that's the whole, you're not an MD, you can't say all this other stuff. But what exactly is he? Did we get an exact?
Sounds like he was a cop. I don't know. I don't know. I don't know what he is. Does anybody in the chat know what Crosby actually is? He's a doctor of something. We're Juris Doctorates. We're doctors of
I'm
law.
a doctor.
We're doctors of law.
Yep.
We're doctors of law. Well, I mean, the one thing that's evident is that in he has said this, Brennan has said this multiple times, that he only would be calling this guy on
Oh,
rebuttal.
that's right. Sassy said he was an animal behaviorist. But that doesn't qualify you to talk about
Wounds.
anything like that.
Right. My dog refuses to stay. Like, could you tell me why? Why won't Nanook ever stay when I tell him to stay?
Hey, Travis, he's a doctor of love.
Yeah. Doctor of love.
Doctor,
So
give me the
what's
news.
evident
I got
here
a
is
bad
that
case of
Brennan is
loving you.
not going to be doing a prebuttal case. Like he is not going to be trying this case the way Lally did. We know that.
Well, he might still be to a certain extent, but
I
we
don't
know he's
think
not going to
so.
call you not as going as far as calling an expert to say it wasn't a dog bite before they say it was a dog bite, and that's just good. That's just good practice. You're better off putting that person in rebuttal. Why in the hell would you put him on first? But I wonder if he's going to apply that same logic, like you're saying.
Well, I
to-
don't know why you'd put on a prebuttal case at all, because it just seems like you're validating the defense's claim in general. I mean, I thought that was bizarre. All right, let's see what else they got. So she's obviously gonna take everything under advisement. She never
Yeah.
rules from the bench.
We're not getting many questions. I was going to say let's address some questions, but not that Mikey. He just wanted to take a moment
Mickey.
to remind Mickey.
Yeah.
Oh yeah, Mickey. I would like to take a moment and remind Bev that any expert, defense, Commonwealth, independent, all get paid by someone. She's blowing this shit out of proportion. Shill.
Agreed.
Filed on February 21st, I believe. Defense motion to exclude, February 21st. Defense motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative of Daubert hearing. So the last time we were here, I wasn't sure we would reach this. I think it had just been filed. So I don't have an opposition from the Commonwealth. I don't know if you wrote one, if you planned on writing one, or if you just wanted to go forward, and also whether you're prepared to go forward today.
We do not have a written opposition, but we are prepared to go forward today.
Okay, so I will hear you. Mr. Leslie, this is you again, right?
It is, Your Honor.
All right, so I'll hear you.
So maybe that was the way he formed the last one. Exclude him or in the alternative, a Daubert hearing.
And this
And
is
then the-
paper 515.
May it please the court. Mr. Gilman, a meteorologist, is attempting to opine on the hardness of soil conditions at 34 Fairview.
What? A meteorologist.
In January,
The weatherman.
January 29th, early morning 2022. He states in what is a certified weather statement, that's quote, certified weather statement, many things, and we don't challenge his statements about what the temperature was and precipitation. But what we do challenge is his opinion with regard to the hardness of the ground. With regard to his qualifications, his qualifications to opine on the hardness of the ground. He is not a geologist. He's not a pedologist, i.e. a soil scientist. There's a specific field for that. He's not a hydrogeologist, which is a scientific discipline that blends water movement in the subsurface, particularly the soil. He's not a hydrologist, which deals with solely movement of water, whether it's in any kind of media, soil, etc. And he doesn't purport to have any of those qualifications. He doesn't even state that he took courses in college that would have even educated him on soil hardness and the effect of precipitation with regard to.
I mean, I took weather in college. Can I go testify? I'll go
Well,
testify.
forensic meteorologists testify to things such as like, what was the weather at the time of an accident? Would they have been expected to know about the impending weather? Um, like things like that. Like if there was like an aircraft or something, like how did the weather affect it? How was it moving? I I I'm gonna do some research about if they can speak to the weather's impact on the ground or something, but it's just seems strange to me.
It seems like it seems like a bad fit. Like why would that guy have any kind of expertise on ground freezing? Because he can predict when a maybe predict when a
Now, he could
nor'easter's bearing down.
I think he
It's
could testify to, like, when the snow started, what the weather conditions were, when it
yeah,
got
that's different.
cold, what right. But to translate that into and when it's that cold, the soil underneath the ground is hard enough for someone to crack their head on, now you've gone too far.
Yeah, I mean, right. Like Sleuthy's saying, maybe they'll say how little snow there was, but that's a different thing. Like in terms of what the accumulation was at a certain point in time, fine, that guy's qualified. Let's assuming that he has the data from that day, which I'm sure he would, but they're talking about whether or not the ground would have been frozen and to what extent. So I don't know.
The hardness of the ground. But perhaps the most telling statement that he makes is he puts his opinion in quotes. So
And
his certified weather statement is hard as a rock, I believe. I'm looking for it.
So I'm sorry, there are a couple of exhibits attached to your affidavit, Mr. Leslie?
Yes.
All right, so one's exhibit 1, I don't see any.
I'm sorry, Your Honor, it's Exhibit 1.
Okay.
It's his February 3rd, 2025, quote, certified weather statement.
Okay.
That is it. And at the bottom of it, it's got in the quotes, the
Okay, I see it. All right. I don't see anything that says certified weather statement. It's an email, right?
no, his report is exhibit, well, it does state certified, and I'm quoting certified weather statement.
Is it NDA 02802 and 803?
It is exactly that.
Okay.
Yes.
What did I do? What did I do?
So Your Honor, he puts his opinion in quotes, which to me is an indication he's speaking in lay terms. I've never seen an expert put an opinion in quotes. And he does not tether that opinion to any methodology. As a matter of fact, Your Honor, and that's the entire basis for what the Commonwealth is proffering is support that one, he's qualified, and two, that his methodology is reliable, but he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is. He doesn't say how he came to that conclusion. So it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence. They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion, in quotes. And Your Honor, there is a deep and typical of science, complex way to determine hardness of ground. And he doesn't even begin to discuss that whole science
And Your Honor may recall in previous Delbert Lanigan hearings, I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. What is the weather? We all know what it is. I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I've never heard it. Because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells one that this is not the kin of meteorologists. And interestingly,
That was hilarious. There's a we're gonna get about 3 inches of snow, and the ground will be hard as a rock. Yeah, I've never heard of what say that. So hey, be careful out there. Your ground's gonna be hard as a rock. Just make sure that you put your grippy shoes on.
the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor, he's not qualified in this area. He doesn't even state a methodology to come to the opinion, let alone show that if he had a methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using layman like an idiom, a term that people just use. His head's as hard as a rock, whatever. But that's not science. And in order to give an opinion to the jury, the whole purpose of general acceptance, the whole purpose of
We all know the idiom we wanted him to use for hard as rock. And it wasn't his head. It wasn't his head.
All right, come
That
on.
would have been glorious.
Come on. You and Jay would be having a little ball here right now.
And it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor, Mr. Gilman, the meteorologist, should never reach a jury to talk about hardness of the ground.
Thank you.
That was glorious.
Mr. Brennan, the first question, do you intend to call this witness in your case in chief or for rebuttal?
I do. Case in chief. Thank you. The Commonwealth proposes calling this gentleman to talk about the weather conditions leading up to the night that John O'Keefe was killed. Talk about the temperatures, the wind conditions, also the snowfall. It seems that the only complaint the defense has is the ultimate opinion that the ground at Fairview was hard as a rock. I think that concern is easily remedied. I do not need to ask this expert if the ground at Fairview was hard as a rock. I can ask him about the documented temperatures, the winds, the snowfall, what makes the definition of a blizzard, how many hours have to elapse in certain conditions to be a blizzard. Also, he can measure the snowfall as it accumulated that night into the early morning hours because there's statistical evidence about it. And I would like him to talk about how ground freezes. Without giving an opinion that this ground was hard as a rock, he should be able to testify that over a period of time, the frost below freezes the ground. I don't need or would not ask Mr. Gilman to talk about the ground hard as a rock. We have a handful of first responders who will give lay opinions with common sense that the ground was hard as a rock. and state police who excavated can testify to that very thing. So Mr. Gilman does not need to offer that opinion. If that's the only thing offending the defense, I think we can resolve the issue.
Okay, would you say that, Mr. Lessons?
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned, but its proposal to have a meteorologist talk about how ground freezes is still very much problematic, because just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that. Benjamin J.G. 2005, freeze thaw effects on penetrometer resistance in shear strength.
Why don't you put those in writing? Was that just a Google search? I saw that you had it on your.
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me. Is there any objection to the Commonwealth to me getting that?
Not at all.
No.
Happy to provide it, Your Honor.
Do you want to provide a copy to Commonwealth as well?
I'd be pleased to provide a copy to the Commonwealth.
All right, so I'll take this under advisement.
Pause it a sec, babe.
So how long do each of you?
So I just pulled up a Connecticut case, Supreme Court. The plaintiff brought suit for personal injuries, which she alleges were caused by a fall in the defendant's parking lot on whenever the jury returned. Okay. In this appeal, plaintiff claims that the trial court erred in its charge to the jury regarding plaintiff's use. I'm sorry. All right. And allowing the defendant's meteorologist to testify as an expert on ground freezing conditions. So the court said the plaintiff's objection, the meteorologist was allowed to testify in his opinion that the ground was not frozen on the date of plaintiff's fall. There was no objection to his qualifications as a meteorologist, but only to his competence to be an expert witness on ground freezing. Whether a witness is qualified to testify as an expert with respect to a certain matter is a decision to be made by the trial court, will not be disturbed unless there's an abuse of discretion, blah, blah, blah. Once the trial court determines the witness has a reasonable qualifications to testify as an expert on the question presented, the objection goes to weight. Here, the trial court permitted a meteorologist with more than 30 years experience to offer an opinion on whether the ground was frozen on a date of the accident based on weather records for approximately 2 months immediately preceding that date. We cannot say the trial court abused its discretion in allowing this opinion to be heard.
I mean, I think there's no question that this weatherman can come in and testify to geological type shit. Like, I mean, Brennan conceded that. He's this weatherman.
You mean Alessi?
No, Brennan got up and he said, okay, well, there's an easy remedy to that. I will not have him testify that the ground was hard as a rock. Were you not listening to him?
No, I did.
I think you were searching for this case and you didn't.
No, I did hear him say that, but I didn't. What I missed was who he said he would call to say. Was he going to say he was going to have someone else call to say that?
No.
Oh.
No. I mean, I don't know. How does that move the needle for the Commonwealth at all? I'm talking like a baseline. Maybe I'm missing it. Like what does, say, in a world that Bev lets him put this guy on and he says, yeah, the ground is hard as a rock. Like what is that helping prove?
He's trying to say that by falling backward that would have caused his head to crack open like that.
Wait, what? We're we're talking about on the grass. We're not talking about on the road. The
Yeah,
road's
no, he's
always
saying because of the snow and the freezing on the grass.
okay, but so they're still sticking with the pirouette and he flies 15, 20 feet through the air and hits the ground. Is that what their theory still is?
I mean, I think it's clear from this if he's talking about soil and ground conditions that he's not talking about the fact that the cement is hard.
Oh, because like to me that hurts. Like there's always been a question of where the hell was all the blood from a head wound? Because if you've ever been hit in the head or had any kind of cut on your head, you bleed like a stuck pig. Like I remember when this trial was going, I talked about like when I was an idiot kid and we had rock fights and some kid hit me in the head and like with a rock and it was like this big. It was like, a small rock whipping rocks at each other like morons. Thing hits me in the head and I'm like pouring blood. I thought my whole head was caved open. I'm running back to my house screaming. My mom, I'm like, my mom's like, oh, it's a teeny little cut. Like it wasn't even like hospital worthy. So, but the point being is that you really, really bleed. Where's all O'Keefe's blood? If that's where he sustained the injury, and how does the ground being hard as a rock help the Commonwealth with that? It's their burden.
I think that it's going to end up playing right into both sides.
Wait, how does it play into the side of the Commonwealth, babe?
I don't know. I think what they have said is that, like, yeah, he did his pirouette thing, and then
flew
he's
through the air, somehow.
some version of that.
Okay.
But I think that it obviously, like you said, I mean, then it's like we both said it. He's throwing the glass, he slips and,
That's
whacks
my
his head on the
theory.
ground.
That's
Right.
my theory. People tend to hate my theory, even though
Hey, when you
I think
threw
that's
the
actually what happened. Like, I
when
don't
you
give a
I
fuck
just
what anybody
said
says.
I just said that if you're going with the possibility of the throwing of the glass, that would be consistent with you throw it, you lose your, you lose
Yeah,
your
if you've
balance.
ever thrown something like just full blast, like on a super slippery surface, you're most likely going to slip and bust your ass and your head. I mean, that's just it's facts on a super slippery surface, especially if you're hammered. I mean, like whatever. I like it, you and I, if we were trying this case, there would be a real battle in terms of what theory we were throwing out there, in terms of winning the case. Just in terms of getting to reasonable doubt and winning the case. I don't know. I don't know. It's like Sleuthy says. So this is so old. Commonwealth needs to stop trying to disprove the defense's theory and instead show how the fuck John's injuries were caused by care. That's it. That's all I give a shit about. Somehow make it make sense to me that John O'Keefe was struck by a 6,000-pound SUV and doesn't have a bruise. Not one contusion anywhere on his torso, on his legs, anywhere. Like on Twitter the other night, some people's like, there's people that get hit by cars that don't bruise. Not 6,000-pound vehicles going 24 miles an hour, lady. Do the research. No, I don't have to do research. I'm not trying the case. The Commonwealth needs to prove that, and they haven't proven anything, even remotely close to that. Because that pirouette shit's ridiculous. And frankly, if his arm got hit, that thing would be a big, giant purple blob. Because the one thing that we know, when they say that he died from hypothermia as well as the injury to the head, he didn't die right away. So the concept that he died instantly and that people don't bruise when they're deceased is out the window for me. I agree, Sleuthy. It's time for them to prove it. They can't. That's why they don't do it. They can't prove it. It's the whole point. They cannot prove that. It's always been the biggest issue in this case. The injuries are completely inconsistent with him being struck by a motor vehicle. And like, like the whole thing with the pneumatic cannon and the glass, my concept that John whipped the glass at the back of the car and just luckily hit the taillight, or unluckily, as the case may have it be, is that would, like, if Karen heard something in the car, because I imagine that would sound loud in the car. If John whipped the glass at the back and hit the taillight in the car, it would sound like, oh my God. Like, so if her mindset was like, oh my God, I heard something, it would completely explain why she thinks that at some point she may have hit somebody, which is a total, like a total, when you combine the fact that you've just found your boyfriend in the yard and compare it or and contrast it or add it to the fact that you think that maybe in your somewhere deep in your recollection, you thought you heard a sound, it would completely explain that. And it would completely explain why she may have been saying, I think I hit him, did I hit him, all that shit. I don't know.
You need to get me what you said you would get me, the Commonwealth, the articles, and the qualifications, the cases and the qualifications of Dr. Crosby.
I can have that to you today.
Great, okay. And those articles, Mr. Leslie, that you were just citing, when can I get those?
Do you want all the citations or the articles themselves?
If you've got the articles, if you've got a copy that'll save me from having to find them and read them, that's fine. If you just give me the links, I can do that myself.
I'll get you the articles, Your Honor, in the text, and it's probably going to take me 2 or 3 days.
Do you have the links? Do you have a list?
I've got a list right with me today.
Okay, so I'll take that. And that'll save you from having to print the articles.
You let me hand it to the court officer?
That would be great. And you'll provide it to the Commonwealth as well. Is that your only copy, Mr. Leslie? Did co-counsel have copies?
Oh, no, co-counsel doesn't have any of this, Your Honor.
Okay.
I just need to black out something here that's,
Sure. You don't have to do it right now. Do it before you leave.
I'll do it before I leave, Your
And
Honor.
that way
Thank you.
there, we'll see to it. Jim, can you get a copy made for everybody? All right, so now, because we're doing them in the order they came in, Commonwealth's motion to impose sanctions. This involves a transcript that I've read. I've listened to the actual recording. Maybe it makes sense to take a 15, 20-minute recess. Now, does that make sense to everyone? Okay.
All right, to the board, please.
Is the Commonwealth going to play portions of this or not? The flash drive has been impounded because I understand the nature of it. Is it all, are you referencing just a transcript? Actually, I'm gonna see counsel.
Take a seat. Quiet, please. Spell the record.
If we're going to try to read the judge's actions here today, I mean, it certainly appears that she has no intention on booting anybody from this case. I mean, she's proceeding as, you know, as if this thing is going on April 1st, like she's doing all the things. So, you know, it's like, I think if the move from her perspective is that she's contemplating removing Jackson, that she's got to deal with that first. And I think the fact that she's not speaks volumes. Do you agree?
Yeah.
All right, to the court, please.
Are they coming back already? Did we have
No.
bloop?
No,
Oh.
we're at a sidebar. We got some time. We can whip right past OnlyFan.
Let's see if we got any questions we can address here. Let's see. Oh, and you told me how to pronounce her name. Is it not Kylie? Kaylee?
Kylie.
Okay,
It
Kylie.
could be Kaylee.
Said
Wait,
cops
which-
can give lay opinion on ground hardness. Said cops can give lay opinion on
What do you
ground.
mean?
Oh, that's what Brennan said that he was, because I was like, well, what did Brennan say that he was going to do instead of,
Yeah, it's definitely Kaylee.
so
Yeah.
she's saying that the cops that were there, that were walking around, that they can, could they touch the ground? Well, I guess they'd moved all the snow. I don't know. But thank you, Kaylee
Man, we
or
had all
Kylie.
that time. It just got eaten up.
See,
And
that's why I gotta pause it when I want to pause and just
we did. We
blab.
did.
I know. I know.
We had 18 minutes. Can't be much more
Well, if
time.
people have thoughts and
Yeah.
questions, super sticker them now while we've got time to chat.
I think we've done all the supers.
Yeah.
Yeah.
But thank you, Liam 07, for your generosity. Thank you for your generosity. Not that Mickey. Thank you for your generosity, Natalie. And not that Mickey also became a new member, as
sweet.
did Tired Night Shift Nurse. Aw.
Oh, and we had Jenny P with the nice $10 Venmo. Thank you very much. And then yesterday, after we went off air, Lisa H kicked us a 50 on Venmo.
All right.
So thank you guys.
Thanks for your
both.
generosity, everybody.
We appreciate that.
Well,
Well, I
so
mean, you didn't really engage in much of a conversation here, which I kind of want to have, like about like if her intent is to remove Jackson, it seems very unlikely considering what's going on in court this morning.
right. I think if she was on that path, she would have taken that issue up right away.
Right.
You know, is it Kale? He wants more Todd Mullins. You
Mullis.
started this.
Yeah, we're gonna
Mullis.
do it. Like, dude, like the thing about Mullis is we can pick that up anywhere. You know, like yes, I'm not abandoning Mullis. I just got to try to figure out when to stick it in. Oof, that's what he said. Wow.
Oh, wow. Come
Wow.
on.
Dude, it's all the hard as a rock talk. Just
Yeah,
getting off on
well,
a weird thing, you know? I mean, come on.
men.
You blame me? Can you blame me?
Men. No, I can't because you're a man.
Yeah.
So
I,
easily distracted and controlled, mind you. It does work in our favor.
So true.
They're
So
just
true.
weak in our hands.
We are weak and worthless when it comes to women. I mean,
Exactly, Kai. Where's Jay? He'd be just red in the face, hysterical.
I was hysterical. Jay, he hit my tweet because I said I had tweeted that I'm like Alessi and Brennan arguing about anything being hard as a rock today in court was not on my bingo card.
Wow.
Jay was like, he's like, I don't think I would have handled this well.
Well, not that Mickey says, in my opinion, if Bev throws witnesses out, Karen Reed will get new ones that will come to the same conclusions. Is this possible at this stage? I would say absolutely, positively. These are the type of things that continuances are made for. But that doesn't mean that the judge will do it. But I think, new opinions from Commonwealth experts. I mean, I'm hoping that like having Alessi there is going to be that constant reminder. If something new comes in, we ask for a remedy right away. We don't not ask for a mistrial when the state puts on false evidence in an inverted video. We don't not ask for a mistrial when witnesses say something surprising or a continuance or, whatever the case may be. So, but yeah, if she limits their expert in some way and they can establish that with time they can get a proper expert to say what they need to say or a different expert to say what they need to say, they should absolutely be given the time to do that. And thanks again for your generosity. Not that Mickey, great to have a new member that just keeps super stickering. You're all great. You're all great though. I'm just saying.
Like there's got to be, in terms of expert witnesses.
Hey, babe, you're not playing because the fan's not moving.
Yeah, we're live.
We are?
Yeah. You can see
Only
it down
fan's not spinning?
You could no, it's like the camera's frozen. You could see the red dot.
But
See
what
the red
about
dot
that
down
little
there?
play button down there?
Oh yeah. Okay.
Wow. Wow. Just use your bloop bloop or that.
All right.
Oh,
Okay.
wow.
Yeah. I mean, I'm always up for being a little bit behind time.
Hit the
So
play button again, though.
I shall, babe.
And we're back, guys.
You may be seated.
I do have an 11 o'clock, so I'll be leaving shorts at some point.
Mr.
Can't hear you.
Larson and Mr. Murray. Thank you both. All right, so the next motion we have is the Commonwealth's motion to impose sanctions pursuant to Mass Work Criminal Procedure 48. Mr.
Is
Larson, do you
he
need a minute?
asking for contempt?
Did you need a minute? I'm sorry.
What?
Sure.
Thank you.
Timmy?
Yes, I'm working on something.
Babe, can you pause it?
I don't
I guess I'm having
don't-
trouble keeping track of all the filings. Have we read this filing?
I don't know what well, look up what Rule 48 is, first of all. And that'll I when I saw Christina Rex had kind of listed on a tweet all of the motions that were up, and she listed this motion for sanctions by the Commonwealth. I'm like, what in the what?
Sanctions of attorneys who violate the rules or orders issued under those rules.
So I did we miss a filing? Is this like, do y'all know?
But
Sleuthy, what's up?
48, oh no, criminal rule. Let me read it. Exactly. A willful violation by counsel of the provisions of these rules or of an order issued pursuant to these rules shall subject counsel to such sanctions as the court shall deem appropriate, including citation for contempt or imposition of costs or a fine.
So we'll find out. I'll bloop it a couple. We'll start
This
it
rule
from
is intended to supplement rather than supplant the provisions of prior law relative to the power of the courts to regulate conduct. I don't know that this is something that
Oh, this is it's about them putting Proctor's text in a filing. The text with Lally about Jackson closing. Okay. I mean, really?
Thank you, chat.
Thank you, chat. Really? They're like going through this shit now.
It just doesn't seem like this is something that allows, based on me, pulling this, looking at the rule itself, that it's something that is supposed to be like a sword by your opposing party as opposed to the judge's ability, the judge having the ability. But
Yeah. Like all I want to say is that I don't know if you saw my tweet last night, babe. I love this Judge Hippler and the Koberger thing. Can I read you? I'm just gonna read you from his new order that came out
absolutely.
late yesterday. I'm just gonna read you the very beginning of the order. So the party's pervasive practice of filing material under seal in this case has become the norm rather than the exception. Rather than seeking to redact discrete sensitive information, entire documents are filed under seal. In addition, much of the material the parties seek to seal is already in the public domain. And this is my favorite part of it. This approach runs counter to the public's First Amendment rights to know what is going on in its courts. This guy's a hero judge. That's what he is. He's a hero judge. All right. So if this is like nitpicking about some bullshit that happened in the first trial and they're trying to ding the defense, I mean, come on. Come on. Really? We're like on the eve of trial and this is some shit that they're pulling.
Great, I want to thank you both for getting me these materials, Mr.
Just trying to divert their attention,
Thank you both. All right.
make them work.
So the next motion we have is the Commonwealth's motion to impose sanctions pursuant to Mass Work Criminal Procedure 48. Mr. Leslie, do you need a minute?
Could
Did you need a minute? I saw you just.
I please just?
Sure.
Thank you.
Timmy?
Yes, I'm working on something.
All right, well, bloop bloop us.
I'm gonna let the time
I
build.
take a 5 minute recess.
All rise, please.
See? Taking a 5-minute break. Bloop, bloop. Now bloop.
I'll see if we have any other questions. Nothing yet.
I mean,
All right.
I think we're 5 minutes behind. We good. There you go.
Hear you on this motion.
Thank you.
The judge in the Koberger case is Hippler.
Yes.
As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred. If there was no need for protective order, there wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule of Criminal Procedure 48, the court can impose sanctions. In this instance, that was the genesis for this motion. There was recently provided materials that the court ordered the defense not to disclose to the public. Those materials, which is some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order. Now, it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, given the history of this case, it is important to make sure that these type of violations don't happen again. What stands out to me in the reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information.
Pause it real quick, babe.
In the memorandum, page 9,
I just want to note that by filing this sanction motion, Hank is not, he's absolutely not trying to prompt the judge to remove any of Karen Reed's attorneys. I mean, he's not. He respects the constitutional right to your continued representation of counsel of choice, right, babe?
Yeah. No. What this is
But he is. He essentially
Right.
he's trying to give her more feeder.
fodder. So
Fodder.
he is. What this really is, though, is this is a fucking snivel fest about how defense attorneys put things in their pleadings and all in order to put forth a narrative. Tough shit.
They're all just
The
watching.
government does it all the time in every single case. The government doesn't like defense attorneys now are making a habit of putting their theories out for the public to chew on the same way that they could chew on the government's theories while we're waiting for trial. Like this,
Right.
this whining, sniveling defense attorney playing prosecutor makes me sick.
And I think he's also doing it under the guise of I'm not asking, but I'm asking.
I get it. Maybe, but the bigger point is that he's doing the same shit that we saw in Delphi. Where
Exactly.
that was the whole narrative. Oh, they're making shit up. They're putting it out there to sway public opinion.
And if you're
Dude.
not listening to the Tunnel Vision series, we're just at the precise moment that they make this same complaint against me.
Yeah, that's right.
Very same.
If you're wondering why I'm so passionate about it, there's a good indicator right there.
what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial. There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness who was not bound by a sequestration order at the time of closing, didn't want to watch a closing, there is no good faith basis whatsoever that that witness watched other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information to the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of a jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is saturating the public with sometimes disinformation.
Hey, dude, they have a different theory than you do. What do you not get about that? All you have is a theory, dude. Quit acting like it's the only one that matters. I am so sick of that shit. I cannot stand it. I love that defense attorneys are starting to put their theories out. This guy standing up there acting like he knows what happened definitively makes me want to puke.
It's just
I
insane.
cannot stand it anymore.
It's
cannot.
wait. This
standing up
isn't
there whining-
exculpatory, Bob. It
Huh?
doesn't, this isn't exculpatory. It doesn't meet what I understand the
I'm
evidence
not
to
even
mean.
talking about that. I'm
It's
talking
the
about
same thing.
It is the same thing. But this guy standing up there just casting shade on the defense for getting their theory of the case out there is bullshit.
And I'd like to note, I
There
don't
is
know.
no rule that says that the state is the only people that can get their theories out there before trial. That creates an unequal, completely biased. The scales of justice are skewed when that happens. The only way they get evened out is exactly what you have here. You don't like the theory? Then prove your goddamn case, Brennan.
Right. And I just want to note that, and I don't know yet because I can't independently recall every single thing. And they redacted it, so we don't know. But if it's stuff that came out in open court, it's no longer protected. It's been released to the public through the trial. And there was something else that I was gonna.
Okay, we all know that Proctor's a giant flaming douchebag. Like that is not a secret. Everyone who knows anything about this case knows exactly who Proctor is and what he's about.
Parts of information that inevitably is going to make a juror's job much more harder.
Much more
It's
harder.
unfair to the court. It's unfair to the people of the Commonwealth. It's unfair to the Commonwealth. It's unfair to the prospective jurors. And so not only is there not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We just turned it over as a text message, and notice of discovery 51, a protective order was issued, docket 416. We produced it, notice of discovery 57. And again, there was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements. And despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer
Does he know
knows
the definition of
or reasonably should
extrajudicial?
know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. There's been an ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The government has, the defense has not only trampled over 3 points.
You mean filed? You mean a motion was filed that contained the information?
Extrajudicial.
Is that what-
Extrajudicial.
Is that what this guy's talking about?
He just
I-
cited the
I
rule
hope
about
to God Bob Alisi is arguing this. I want Bob Alisi to be our, please. If he does not flamethrow this guy, this double standard bullshit that the government thinks that they can stand in a court of law and say this kind of shit. Who do they think they are to even suggest that the defense doesn't have the right to have a different theory of what may have happened? Who does he think he is? It's outrageous.
and just to
Like,
note,
I
most
cannot
of the
stand
time,
this dude. I
most of
cannot
the-
stand this dude.
but most of the time the defense isn't doing this because defense likes to hold their cards close to the vest. So,
I don't think that should be the case anymore.
well, but then they're already preparing to combat you. So
Okay,
as
but
much as
so
you
what? Who cares? I mean, I guess that you're weighing, would you rather even or try to even the scales of justice leading into trial?
no, I wouldn't.
You'd rather hold it to your vest?
If I could, yeah.
I wouldn't. Why?
I mean, it depends on the
Everyone makes that
scenario.
decision by the time they're in that court of law. Those jurors have already decided. You know it and I know it. I can't even believe you're saying that.
Well, hopefully, voir dire proves that they don't.
Oh, good God.
I mean,
Are you
jury
serious right
selection
now?
proves that they
Jesus.
don't, already have an opinion.
How's that panned out?
Right.
during
No,
our
I
20+
agree
years?
that if a juror wants to get on, they know what to say if they formed an opinion.
It's not even that. Like in a case like this, high publicity, there's not going, like, for whatever reason, they've decided not to try to get a change of venue here. Why? I'll never know. I'll never know. I'll never understand it.
Are you going to get a change of venue when you're dealing with a county that, as of right now, especially with everything that's happened, sees corruption, corruption, corruption? That's what's in the news all the time. Police lying, police killing,
Then the state can also file for a change of venue.
and say that our I'm sorry, Your Honor, but our residents do not trust the police because
No,
they are
you're
just
saying,
so.
Your Honor, that I don't think that we can get a unbiased jury in here. This community is too saturated. I mean, like you see it all the time. There's many cases where the state or the Commonwealth does not oppose a motion to move it out of a county, because the same thing happened in Kohlberger. The state was they were on board. We got to get it out of here. The communities, it's too saturated. There's no way they were going to be able to get jurors that haven't heard about this case, and whatever their opinion is. You don't want jurors that have heard about the case, no matter what their opinion is. My point being, I'll argue to the death on that one. Like, I love that defense attorneys are getting their theories out there. I don't think we get enough of a benefit by holding that close to our vest.
All right, let's hit play.
At all.
People want to hear
They've
this
alluded
nonsense.
continually about matters that have no basis in fact. January 18th, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by
Bloop,
Mr.
bloop a little
Yannetti,
bit. Let's hear that again.
and I have a clip of it.
Go for rewind a bit.
He also
You want me to rewind it?
Yeah. Just a little.
is in what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18th, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on court TV with Miss Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is,
Where was that court TV again?
I can get the date for your honor. Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, The Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court there is no longer.
How is he even saying this stuff with a straight face? Like, honestly, I mean, we have heard too much about too many of these cops for him to be sitting in a court
I was
puking this shit out.
I was pulling up. I have when they spoke on Court TV on January 18th up and ready if you ever decide you want to
Yeah,
hear it.
we'll pop it up when we get a break.
Okay.
Any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality or fact. And so I submit that the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that. If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance, they can't be. Doesn't matter who you are. And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will abide by the same rules. What I suggest is that from now until trial, all pleadings submitted by the defense should
No
be
way.
under seal.
No
so
way.
The court and the Commonwealth can review them and make any objections if there's any material that's private, so that there's no oversights or mistakes or dissemination of protected material. And then if the court and the
She might do
Commonwealth
that.
does not have any objections, then those materials can be provided publicly on the docket.
It's exactly why I just read Hitler's court order.
Well, but he's not asking that they actually go under seal. He's asking that they are previewed by the Commonwealth and the court before they're filed of public record so that they can make sure they've got no objection and that there's no accidents. So it's a little different.
That's not what we do. That's not how the courts work.
Well, I think that it could be a sanction. I think it's something she could do here. It doesn't mean that they can say, well, we'd have to see if they ever try to, if the Commonwealth asks that something be redacted, that's when we can get, up in arms. But yeah, if I'm these attorneys,
down to the fact that they're poo-pooing the defense's theory of the case. Hank Brennan has no idea what happened that night. For him to be standing in a courtroom pontificating as if he does is complete and utter bullshit, Allison. He's got no right to be standing in here. Well, our theory's the right one. Everything they're doing is a smear campaign. Bullshit, dude. Their theory is that those people in that house did something. You may not like it. You know how you remedy that, Brennan? Prove your goddamn case, dude. That's how you do it. If you had a strong case against Karen Reed, you would not be in here sniveling like this right now. Period. If they had powerful evidence to get this case to a jury and get a conviction, we wouldn't be hearing this right now. You know it and I know it.
Exactly. No, I can't agree with that anymore. I mean, that is abundantly clear.
Well, I'm so over this shit. I'm so over it. Like, just not in this case, like in general.
Also, the Commonwealth suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does.
That's
No more symposiums on the courthouse stairs. No more interviews with national media. No more statements to press privately behind the scenes over a coffee, putting out information, oftentimes inaccurate, to sell the story before the trial starts so that we can have a trial on fact. There should be a gag order on all of these attorneys, every single one of them.
You mean of us?
And the Commonwealth will not speak either.
We want you gagged too.
Ms. Reed, I'm not asking for a gag order for.
Of course not.
In light of the history of these repeated violations, in light of the inability for the defense to restrain themselves, in light of their purposeful, intentional, and obvious efforts, in order to best try to maintain a fair jury in this
All right,
case,
just shut up
is to
already.
impose those sanctions, and that's what I'm asking for. Thank you.
All right, who's getting up?
Mr. Nettie, you're arguing this, you said?
Yes, Your Honor, may we approach, please?
See, he's running scared, being over cautious.
All right, let's see what we got.
Thank you, Lynette, for the birthday wishes and for the generosity. Appreciate it.
Oh, Yannetti. All right. He would have been my second choice. I haven't heard from Yannetti. He's always been my favorite till Bob got on the team.
Thank you, Your Honor. And may it please the court. Your Honor, as I mentioned at sidebar, I intend to make less of an argument here and provide more of an explanation for the content of my motion regarding the reciprocal discovery. And at the outset, as I mentioned in court last week, this was indeed my motion. Mr. Jackson's name is listed first only because I used a template for the signature block, and that's why I'm addressing this today. And regarding the motion itself, I do acknowledge that I did not file a motion for impoundment when it was filed. And to the extent that that lack of impoundment is not congruous with the protective order, it was neither intentional nor willful. It was an oversight, not an attempt to flout any rules of this court. And while I do ask the court to take my word for that, I do also submit that there is evidence to back up that word. Specifically, I would note that one of the examples I cited in the motion deals with the testimony of a juvenile. And when discussing that testimony in the motion, I made sure to use initials, not full names, so as to protect the juvenile's identity and to comply with the court's protective order. That's evidence that I did not intend to violate the protective order and that I was mindful of it in that instance. Regarding the communications involving Mr. Proctor, I frankly and simply did not connect that topic to the protective order when I was drafting it. It just did not register with me. It got by me. When I read Mr. Brennan's motion, I went back, looked at the protective order, and then it sure did connect with me. So I immediately called him and I was transparent with him about what had happened. And so we get to the issue of whether sanctions are appropriate. And I recognize the court's discretion in this regard. With regard to this issue, I believe it is worth underscoring Mr. Brennan's reasons for seeking the protective order in the first place. He listed 3 reasons for the protective order when he filed the motion. And I quote his reasoning here. This order is necessary to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. So the Commonwealth sought to have this court issue the protective order to protect, number one, privacy interests, number two, safety interests, and number three, preserving the integrity of other investigations. And I submit, Your Honor, those interests are all laudable. And I respectfully submit that my disclosure here did not undercut those interests. Regarding any privacy interests, Michael Proctor's opinions about Karen Reed and her attorneys have been well established and was well-known public knowledge
Bob,
as a
you're
result
muted.
of the
Bob,
first
you're muted.
trial. His
Look at
opinions
the-
about my client and me were publicly aired at trial when his other text messages had come to light, inadvertently revealing that he feels the same way about Mr. Jackson that the public already knows that he feels about Ms. Reed and me is a disclosure, mistakenly, that should be considered in light of the circumstances that already existed in the public domain, I would submit. And while the protective order covers this communication, I will note that it was certainly not an instance where I, flagrantly revealed,
Is it boostable?
or inadvertently revealed social security numbers, addresses, dates of birth, private information to that effect. As for safety interests, which was the second reason for the motion for the protective order, revealing that Mr. Proctor has opinions about Mr. Jackson does not jeopardize or otherwise implicate his safety, I would submit. At all times during this investigation, and to the best of our knowledge, Michael Proctor is still a Massachusetts state trooper, and he's already on record with his well-publicized opinions as a result of the first trial, again, about Karen Reed's attorneys. So further information coming to light in this motion that he feels the same way about Mr. Jackson that he does about me does not move the needle, I would suggest, toward jeopardizing his safety at all. And finally, with regard to the third reason for the protective order, I revealed no information about any other pending investigation. In this message, Mr. Proctor was strictly discussing Mr. Jackson. Mr. Jackson does not represent any other individual that Mr. Proctor or the Norfolk DA's office is investigating. He represents Ms. Reed. And so that message from Mr. Proctor was strictly about this investigation and no other. So, in conclusion, Your Honor, I told the court I'd be brief. Protective orders serve important and laudable purposes, and attorneys, including me, need to be diligent in abiding by them. I exercise diligence in abiding by the protective order that this communication brought by me. The court will obviously determine the matter, and in making that determination, I simply ask that the court consider the interests of the protective order that were laid out by the Commonwealth and discussed by me here, and as well as whether there is a degree of prejudice that would warrant a sanction. Thank you.
Do you want to address the disclosure of grand jury minutes?
I am prepared to do that. If Mr. Brennan is resting on his written submissions, then I can give my oral argument now.
Mr. Brennan, you already argued this, right?
Did you try boosting, babe?
I do have concerns about my ongoing obligations, so
I haven't seen anybody saying they can't
Yes,
hear
we
anything.
keep putting it up. That's why they played that, Bob, you're muted, so that you would look at the comments.
I couldn't hear it because it's so loud for me. The court's so loud. Ann says court volume is fine to me. Dorothy says yes, hard to hear. I mean, I'll try to crank it up and make sure you crank your mic down.
Well, I want to hear if it actually makes a difference, because if it doesn't, just turn it right off.
Well, it's been boosted. It's always been boosted. It's been boosted the whole
I think
time.
I think only you're hearing it. I don't know why. You're boosting it on the,
If I turn it off, you guys, I'm boosting it on the screen that I'm sharing, which is the one that matters, not on ours.
I have a moment, Cyber.
All right, let me try to bloop, 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 bloop.
Bukaki.
It's a long sidebar.
No, I'll have to check it when they come back how the sound is.
Bukaki.
Mandy's just as bad as you and Jay.
She's way worse. She's way worse.
All right, I've got damn it. A meeting. I was trying to find
Yeah, we're live. So it looks to me there is okay, we've done the defendant motion to exclude Crosby, the defendant motion to exclude Gilman. We're currently doing the Commonwealth's motion for sanctions. They have this ARCA motion, which has been argued. So I don't know if that means it's just going to be addressed. And then there's the scheduling order, which I think is relating to the motion to dismiss. And then the motion to reconsider a decision about the Canton police station video. So looks like there's only a couple more left. But I don't know what this this ARCA motion. I don't know if that's obviously that's not going to be litigated. It's been litigated. So now it's a matter of I don't know if that's just talking about
Boring.
yeah, I want to hear the motion to dismiss. Time is of the essence though. Like I was saying, the way she's operating today in terms of hearing these particular issues is indicative that this thing is going April 1st. So, which, I mean, she has to know. She knows if she were to remove Jackson, pull his pro hoc, that they'd be filing either an interlocutory appeal or something of that nature, depending on what the procedures are there, and which would stay the trial. Well, it would stay the whatever's happening in the lower court. Yeah, I know we're paused, but we're I don't think they're back yet. I always like to try to get a little extra time if I can. There you go. We got only fan and really only light. Yeah, we are. Let's see. Yeah, we're live.
we just got something else on Alan,
What? From who?
the clerk.
What's it say? I didn't get it.
All right, hold on. I just sent an
My
email.
clerk's been slacking. Like she sent me yesterday's shit today. She's like, "Oh, sorry, I was out yesterday." I'm like, she's like, "You might have
Second
got
amended motion. Oh no, it's just another motion to intervene. There's been a couple of those. All right, I'm gonna have to leave because I've got this. I've got a call, so I'll be back.
All right, hurry back now. You hear? Yeah. Man, I really want to I got to figure out this email thing on my computer. It's disconcerting. So what do you guys think? What do you guys think? I mean, frankly, the violation of the protective order was the exact issue that Allie ended up getting booted on Garcia for. So, but like in that sense, Allie's right. It's like he's continuing to try to give little reasons in why but he's like he hasn't filed a motion for sanctions against Jackson. It's like he keeps inferring that that's what should happen, but he won't file it because he talks out of both sides of his mouth. Oh, Brooklyn, you guys definitely think. Definitely. He is. I mean, I think there's a cap though. Like they raised the cap to 275 for Brennan. Go back to it.
Back in session, you may please.
What's happened? Wait, they're back in session, but then they're not. Was that a just kidding? It's kidding. Samantha, we recorded it yesterday. It should be out in a couple days. We recorded it. Took hours, almost all day yesterday to get that episode recorded. So that's why we weren't covering Mullis yesterday, because I was going to do Mullis, but I had to get that episode done. It had to be done. Had to be done. Yeah, but they just got back from a sidebar. Okay. They were just sidebarring, and now they said court was back in session, and then they sidebarred again. I mean, at this point, with this case, I mean, it's all out there. Like nothing's new. But Yannetti, he made an admission that he put something out there, should have impounded it first to let the judge decide whether or not it was violative of the protective order. But these protective orders and sealing shit, I'm done with it. I'm done with it. And it cuts both ways. It cuts both ways. It really does. It absolutely cuts both ways. I mean, there are certainly things that the defense in cases doesn't want out to the public. But, and I talk about this actually on the upcoming episode of Garcia. Like, that's kind of what my intro is about, like touching upon this exact subject matter. It's like this concept that the state is always the one that gets out there, and you hear it. It's at the time of arrest. As soon as they go out there and they have their presser and, they discuss the arrest and they inevitably start talking about what evidence they have. And they throw their theory out there. And it's traditionally been the case in our country that goes unrebutted until trial. And I mean, if you don't think that causes people to form an initial opinion on a case in terms of innocence or guilt, then you're just not being honest with yourself, because it absolutely does. Yeah, I can't, like, Let me see. She emailed it to me. I don't know if she did email it. Okay. All right, let me see if I can pull it. So I'm saying, Mandy, my email on my computer is down for some reason. I don't know why. It's super annoying though. Lunch break, that's what I'm doing. I'm fixing my email. If we make it to a lunch break, if this thing doesn't finish. All right, let me see. God damn it. All right, hold on, y'all. I'm trying to find this thing. All right, so I'm gonna keep an eye on this. As soon as I put this up, they're gonna come back. Watch. Watch. This guy up. This will probably be loud as shit. So hold on. Let me turn the boost off. Okay. All right.
Who is, you'll hear his voice. He wasn't in the courtroom, but was appearing via Zoom in this hearing in the Karen Reed case, and gave the world, the judge and the rest of the world, an update on that federal investigation of the investigators. Take a listen.
On that score, something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reed defense team participated in a conference call yesterday with a representative from the U.S. Attorney's Office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth.
The investigation is taking place now. As Karen Reed is getting ready for trial on these murder charges,
what that hearing from continuing to prosecute this case. I expect that motion will.
Thank you for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself.
We didn't miss anything.
My argument at sidebar.
Wasn't worth backing up.
All right, Mr. Kennedy, go right ahead.
Thank you, Your Honor, and thanks to the court for allowing me to make much of my argument at sidebar. The only remaining argument that I can make in.
We did that because that was material that needed to be done it. Simon.
Oh, I understand, Judge. Oh, no, and I'm
I just
thanking,
want the record to be clear.
I understand, and I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the first assistant U.S. attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing. Those are her words. Mr. Brennan knew that. It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and Mr. Brennan was aware of that because he personally got the letter. It was only after that that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So what was the date that Ms. Little made that statement? And what was the date that you all found out about what Mr. Brennan just announced?
Okay, so January 30th was the letter. We believe February 18th, when we were before this court, was when Ms. Little made that statement. And then it was thereafter. I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information? When did you hear the information that Mr. Brennan just told us?
Mr. Brennan called me to inform me of that. I don't remember the date. Maybe, perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after February 18th. Yeah, no, it was definitely after February 18th. Ms. Little reported the freshest information that we had truthfully to the court. So just in closing, Judge, this was not a boogeyman. The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th, and it's right there in black and white.
Okay. Any follow-up, Mr. Brennan?
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yannetti on February 26th. The import of the argument is not that the defense was aware it was closed and continued to persist. It is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it, when the reality is now that that case is closed.
If I may just briefly respond, Judge. I'd like the court to take a particular care when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in court to Your Honor. The Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
Also, under the umbrella of the rules of professional responsibility.
Correct.
Court TV was not in the courtroom.
Okay. Thank you. So what I'd like to do now, there are new motions that were really just filed. And what I'd like to do, I have one that has a response. So it's the motion to amend the scheduling order to give the defendant a little bit more time for their motion to dismiss and the Commonwealth's opposition. I would like to hear that now. We need to give him a minute. The parties have any problem hearing that motion now? It is a
No, Your Honor, I think it's very brief.
motion. All right, so I need 1 minute, Mr. Jackson. Jimmy, I have to put it away from the ones from this morning, the new ones. That the proof of it. I have to check. All right, so you're both prepared to argue this motion, right? The motion and the opposition.
I'm so sorry. Your Honor.
So both sides are prepared to argue this, the motion to amend the court scheduling order,
Yes.
and the opposition, is the Commonwealth prepared on the opposition?
Your Honor, we filed an opposition. I just informed defense counsel if they're looking for a date this week if the court's available. I just don't want this to linger.
So I'm happy to do that. The 17th is out. It's way too far away. But I will hear you. I know what I think is a reasonable date, but I will hear you to see if you need more time than what I think is reasonable.
I'll agree if they need a few more days without opposition.
Given that, may I, speak with
Yes.
counsel? May I address the court, Your Honor?
Okay.
Thank you. Very briefly, and I appreciate Mr. Brennan's accommodation. We received on Friday about 400 pages of new discovery, including most of it is probably not attendant to the motion to dismiss, but there are several reports, I think about 4 reports from Trooper Buchanan, Officer D. Jim Petro, D.I. capital G-I-A-M, Pietro, and 2 reports from Lieutenant Tully that are specifically attendant to the issues involved in the motion to dismiss. And then last night we got additional videos, video evidence, both 9 videos of the download process of Sallyport videos, and then about another 15 actual videos. I basically,
What's the quality of those videos? Are they poor quality?
I wish I could tell you. One of them came in, one of the batches came in after I was already asleep last night. I think it came in probably 10 or 11 last night, and I didn't see it until this morning. I've not looked at any of them.
Does anyone on the defense team look different?
I know Ms. Little was,
Your Honor, I briefly looked at them. It took about an hour last night at 9:30 p.m. to download everything. I cannot represent to the court that I've gone through it in detail. I saw what was there. I'm generally aware there are about 8 videos that were produced of them filming themselves dragging files that cut in and out. There's about, don't quote me on the exact number, I believe approximately 9 videos from the Sallyport garage, maybe 12. I have not watched them in detail.
But have you noticed the quality? Is it something that you can actually see, or is it blurred in?
I think some of them are at least the same ones. Some of them I think are blurry. I haven't watched them all in detail. I can tell you that they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in detail. It was 9:30.
Thank you. All right, go
So-
ahead, Mr. Johnson.
Your Honor, just to close, I think that if I have overnight this evening, I think I can be ready by tomorrow. I'm generally ready. I just want to make sure I'm not missing anything, leaving anything on the
So
table.
what I was thinking by way of scheduling, we've gone through just about everything we need to go through today. I just wanted to, because it's about scheduling, what's the Commonwealth's position on Ms. Little's, or I assume it was Ms. Little's motion to filed by Ms. Little motion to reconsider my previous ruling on the videos. Do you want time to file something on that? Are you prepared to argue that today? Because I can tell you the options that I have for scheduling.
We've already downloaded the videos and provided them to yesterday pursuant to the court's directive.
Okay, so that was going to be another issue that I have.
I have not looked at them, Attorney Lally did, and he represented that they're all the videos we've already turned over, same quality as we previously provided. They're just copies of the same videos, although I do want to make sure the defense has an opportunity to examine them for themselves. But those have all been done, so the idea of revisiting them, we passed that.
All right, so in order to keep moving this case forward, because I know how hard everybody's worked, what I was going to propose, based on my review of this, because I could just say no, which I'm not going to do. I would like anything that the defense is going to put in writing. If you're going to supplement this, and I would keep the supplement just limited to the Sally Port video and related evidence. That has to be filed by Thursday with the idea that we will have a hearing on this on Friday. We have Friday already blocked off. This way here, you can all leave for today. And we'll come back Friday with this. But I'd like it filed no later than 2 o'clock on Thursday, Massachusetts time. We've been getting things coming in later, including something from Mr. Yannetti after 5:30 one night. So we need things filed by that court day. So you can have anything that the defense wants to file by 2 o'clock Thursday, and we'll see you all here for it how long do you think it'll take to argue the motion to dismiss?
Your Honor, I would expect my comments, just based on what I have so far, an hour plus, perhaps an hour and 20 minutes, something like that.
Okay. Commonwealth's response, any idea?
Of argument time, Laura?
Yeah.
It really depends on what the defense argues, but it typically is less.
So if we start at 11, we'll finish Friday?
Of course, yeah, yes, I believe we will, for sure.
How does that schedule work for people?
It works for the Commonwealth.
I need to ask this little one quick question.
While he's asking her that, that would mean that we do not have to appear tomorrow.
Right, you're in federal court, I want you to be able to just
Thank you.
go do that
Thank you.
and not have to come back here tomorrow.
Yeah.
And I'm trying to consolidate this now so you can leave in half a day today, rather than coming back. I'm just trying to make the best use of everybody's time.
Much appreciated.
Your Honor, 11 o'clock would work. I think I can make my flight. By the time we get done, I can get to the airport. That's fine.
All right, so where do we stand in the motion for reconsideration? Sounds like the files have already been provided and it's done.
Your Honor, we still would like to be heard as to that. Obviously, we gave notice that we were seeking a motion for reconsideration on Sunday night. They did the download Monday morning after they had received that. There is still metadata, we believe, on the Camden PD drive. I think we're entitled to that. I think the law is clear. I would like to be heard on that issue. Obviously, we can't take back what they did. They have moved the files, and by doing that, it does alter the metadata, as our expert put in his affidavit. It may be lost, but we'd still like to have as much information as we can as it relates to those files.
So how long does the Commonwealth need? I know this motion was just filed. How long does the Commonwealth need to be prepared for this motion regarding the metadata specifically?
I think we'll file a written response.
Okay.
We're going to be a couple of days.
Okay.
And we have motions on maybe Friday.
Yes.
So I think I'll make a motion in writing, but I think we will hope to have the weekend if we're allowed, because with all of these hearings, it's taken away quite a bit of our prep time.
All right. Can you argue it on Friday and file a supplemental afterward?
I can do that.
That way then we can have everybody here Friday and I don't need to bring everybody back Monday.
We can do that now.
Your Honor, I ask for the same courtesy for the defense. We have all of our reciprocal discovery due on Thursday. We have all of our motions and we due on Friday. I know the court would like us to have, the brief as to the motion to dismiss on Thursday, and I would love to be able to get the court that. But I would appreciate a little bit additional time as well.
So I need to know how this affects the motion to dismiss them, right? You've had this since, so you've got these recent ones, but I need to know how that, are you going to argue that on the motion to dismiss?
Well, I I don't know because we got it last night at 9:30, so I wish I could answer that for the court, but I'm in a bit of a catch-22. It might be irrelevant, it might not change anything at all. I won't know until I have a chance to actually go through everything.
But I need time, right, I need to know by Thursday. It doesn't have to be a complete report, an outline even, would the Commonwealth be satisfied with an outline? You know what the points are?
An outline of what you are.
Of what Ms. Little says, how this disclosure of, this late disclosure of videos.
Sure, we'll deal with it.
All right, so if you just so that I know the points that you're raising for the motion to dismiss, and then I'll want to supplement it very quickly thereafter. I have to decide this and put something in writing. So I need it to be done as quickly as possible. We've got a team of lawyers. I know the lion's share of the writing appears to be on you, Ms. Little, but there's everybody here that can help.
May I have 1 minute?
Nice.
Your Honor, given what Mr. Lee just said and the court's concerns, I take Mr. Lally at his word that the new videos are duplicative of things that we already have, which means it's not going to make any difference whatsoever. Could I ask the court if it's okay with Mr. Brennan, we can be here tomorrow afternoon, tomorrow late morning, right after the federal court proceedings. Let's just argue this tomorrow. I will concede.
This, what?
The motion to dismiss. I think I'm pretty much ready now. I can be ready by tomorrow. I need to add a couple of things about the new reports, but if the videos are the videos, then I don't want to wait. I don't want to waste the court's time the rest of the week just to come back and say, okay, well, basically it's the same thing. It's the same argument that I would have made today or tomorrow. So I think we can do it tomorrow if that's okay with the court.
Are you waiving the additional argument that Ms. Little says? Are you saying now that when Mr. Lally told you that, you accepted and that's fine?
I accept his representation is true, and I don't think that we need to file a supplement, which is really where the hang up is. I don't think we need to. If the videos are the videos, we don't need another supplement.
All right. Ms. Little doesn't look thrilled.
Right. Her key was the waiver. I'm not waiving anything on Ms. Reed's behalf, but if we need additional time, we can certainly let the court know tomorrow that we can file something supplemental. But the crux of the argument can be made tomorrow. I will be ready to argue tomorrow.
Okay, what's the Commonwealth's position?
I'll defer to the court. I know it's more complications with the defense and travel will be available whenever.
So I think we did log off today and tomorrow, with the understanding that the defense team would not be here until sometime 11 o'clock or later. What about, Ms. Little, the motion regarding the metadata? Commonwealth needs time for that. Are we coming back Friday for that?
That's fine, Your Honor. I'll be here on Friday.
If you're going to be here on Friday.
I just won't be here on Friday. So if we do the motion to dismiss tomorrow, I can head back tomorrow evening. And Mr. Little will handle it's her motion anyway.
I greatly want to accommodate the defense as we have the entire time we've been here, but we have trial prep to do as well. In more court hearing days, we have hours of conversation, the more time we can't meet with witnesses and prepare our case. And so I want to make things as easy as possible for the defense. I do.
All right, so Ms. Little already filed the motion for me to reconsider. Why don't we hit that tomorrow as well?
Very well.
Okay, and then we'll just finish up everything tomorrow.
Very well.
All right, and then you won't have to be here Friday, but the motions in 1A are all filed. It also involves filling out a final trial conference report. So
Understood.
we need to do that as well. That all has to be done by Friday.
Understood.
And then, my goal was not to bring you back one day at all next week, because then we're gonna have a full hearing. I believe it's the 18th, and the motions in 1A.
That's right, the 18th.
All right, so you have a whole week next week to, you and I both,
Okay.
try and get everything done.
Should we file a formal motion to ask the court's permission for delay from Friday till Monday.
For the
Motions eliminated.
Commonwealths were due on, the defense were due on Thursday, Commonwealths on Friday. Were they all on Friday?
Reciprocal discoveries due Thursday. We want that to happen. Motions eliminated, I believe, would be Friday.
Ms. Little, would you like the weekend for all those motions eliminated?
I would appreciate that, Your Honor.
All right, I'll give you both the weekend.
Thank you
All
very
right,
much.
motions eliminated to be filed on Monday.
There's one additional housekeeping, Your Honor. There is also a motion pending, the dollar motion for Dr. Wolf. It has not been heard yet.
A Daubert motion for,
Dr. Wolf is a neurologist. So there's
oh,
one
I thought you
additional.
meant, I was thinking the archivist.
No, Your Honor, it's the neurologist of the Commonwealth. Wolf with that name, WOLF. That was filed, 2 weeks ago, I think.
I have not seen it.
I'll make sure the court gets a copy, but I know that was filed several weeks ago. I'll confer with Mr.
The Commonwealth must have received it.
We did. We have a Wolf as well, and I received their amending motion, and we'll be prepared anytime to argue that.
Do you want to argue it tomorrow?
I'm comfortable arguing tomorrow.
We're prepared.
All right, so we've got an awful lot to fit in tomorrow. All right. If you get word that you'll be leaving the federal court and can be here before 11, please let us know.
I believe I might have Mr. McDermott's cell. I'm happy to text him as soon as we're leaving the courthouse.
All right, just contact the clerk's office.
Sure. Okay.
Anything else for today then?
Not for the defense, Your Honor. Thank you.
So I'm gonna give you all of the, why don't you fill out all the signs, I'll be out to teach you.
Court call, guys, please.
All right, so there's that. So yeah, if you guys were why I wasn't sleeping, I had tweeted out that they were doing the motion to dismiss on the 7th, and then of course Jackson stands up and says, "Let's do it tomorrow." So I was trying to edit it, and it wasn't letting me edit it, so I had to delete it. All right, so tomorrow, the big day. Big day. Motion to dismiss will be argued tomorrow. I'm assuming, since she didn't clarify, she was going to have that Friday date start at 11. Would have been glorious for all of us, except for maybe people on the East Coast. But for us in Central, Mountain, and West, that would have been glorious. So I'm assuming that it's going to start tomorrow at 9. I'm guessing, because that's when it's on the docket for. So we will obviously be covering that. So for as far as today goes, I'm going to read through the motion that was filed in the Richard Allen case, see if that's something we're going to want to jump on a live, maybe early afternoon. See if we want to cover that, because tonight Allie and I are celebrating her and visiting our grandchild at the same time, doing both those things. And then we'll have to spend Allie's actual birthday on the 5th. We will be covering the motion to dismiss. Can't miss that. Can't miss that. So that'll be interesting. But the takeaway from today, it does not appear that Jackson is getting booted from the case. I think if I were to ask him, he'd be like, "Yeah, I feel pretty good that I'm not getting booted." We would have heard from him, "Yeah, Songbird's going to get moved to Thursday." Let Lauren know. Thank you for reminding me. Songbird is going to get kicked to Thursday because I have to let Lauren know. Thank you for the reminder, because this whole baby plan happened yesterday. So, but it looks to me that Jackson's not in peril. He's staying on the case. I imagine that if that was not the case, that Judge Bev wouldn't have him arguing the motion to dismiss tomorrow. Right? That makes sense. Oh, so it is at 11. Perfect. Thank you, Nicholas. Thank you, thank you, thank you so much. I appreciate that. Meg, I had just said I'm going to read through the newest filing in Delphi. I'll decide if we're going to do a probably mid-afternoon live today. But 5 o'clock, the Q&A, Murder on Songbird Road, will be moved from today to Thursday. And that'll be at 5 o'clock then. And again, remember, got Sean from Potentially Criminal. He's coming on Thursday, not Wednesday. I misspoke yesterday. And then Kirk Nermy's coming on with us Friday in the afternoon. That'll get scheduled here. So keep that checked. With Kirk, I imagine we're going to be talking Reed. The rule with Kirk is we don't talk about his former client at all. We don't mention it. We don't talk about it. It's like I said yesterday, it's like Fight Club. First rule of having Kirk on a live is we don't talk about his former client. So that's the rules. Them's the rules, y'all. So I lost my shit a little bit today. Like I'm so over that. I'm so over the position of the state and the government. Poo-pooing defense attorneys putting their theories out there. It's just I'm beyond done with it. So all right, I think that'll do it. Let me go through. I think we thanked everybody. Liam, we appreciate you always. Not that Mickey. Allie thanked you. Got some new members. Natalie, I know that you were thanked as well for your super, but thank you again. Now that Mickey, welcome to the fam. Tired night shift nurse. Thank you for your service. Thank you for being a first responder over there. We appreciate you so much. My son is a firefighter, so we have great love for first responders over here at our house. And welcome to the family. Family hug. And then not that Mickey came back. Appreciate that. I think we read your comment as well. Kaylee, we appreciate you always. Kale, thank you. Todd Mullis, I promise we're going to do Mullis. I'll figure out when to do it. It's probably going to be next week, like after the fact, which kind of sucks, but maybe over the weekend. Like I rarely do lives on the weekend. Maybe I'll suck it up, Buttercup, and do a live on the weekend. And then not that Mickey came back again. I think we got to that. And then Lynette, I'm pretty sure. Maybe not. Thank you, Lynette. I'll make sure that Allie sees that, and we appreciate you very, very much. OG, 17 months. That is about exactly when we started putting content up on our YouTube channel. So thank you for being OG, Joanne. We love you. Thank you, thank you, thank you. And then Cindy Dewey. Thank you. Thank you, thank you, thank you. We thank you guys all for your generosity always. And Dawn coming in late with the $20 holla. Appreciate you, Dawn. Thank you so much. And also we had a couple of we had the Venmo. I think a Venmo came in. So thank you for that as well. We always appreciate Venmos. They're the best. And that was Jenny P. So thank you. So you guys keep your eyes peeled. Make sure, please, on the way out that you like, share, subscribe. Just tap that like. Super easy to do. Really helps the show. Gets us into the algorithm, because it's like whatever the algorithm does is it picks up if people are liking something, like, oh, this is content that we like. So it helps get it out to new people, and we think that we're worth watching. So hopefully you do too. And if you do, we'd really appreciate you sharing, and subscribing. If you're your replay crew, always leave a comment. That keeps it in the algo as well. As long as it's seeing action on a live that is now no longer live, that will help draw people to watch it after the fact. So all those things are super helpful to us, and we are super, super, super appreciative. So just remember the algo, the algo, the algo, the algo, the algo, 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 derp, 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 derp. All right. So you guys are the best. We love you, mods. I love you. I love you all. I apologize for not thanking you last night after our Delphi. You guys are the best in the business. We love you so much. We couldn't do this without you guys. You're amazing. So we will see you later. Keep your eyes out. If I'm going to do that Delphi, I'll put it in the community notes. You guys will get a little email. You should get an email on it if you're a subscriber to us. That should pop out. And you guys will be aware. I'll also tweet it, obviously. But it'll be a last minute decision. It'll be based on what Allie tells me she wants to do. She's the boss. You guys all know that. All right, you guys, we love you because without you, I'm just an old man talking about a bunch of cases.